All right, Councilmember, you've been joined by Councilmember Henderson. We're now live on YouTube and record as well as on cable, and we are recording on Zoom. You may begin when you're ready.
Good afternoon. I'm Robert White, Councilmember at Large and Chair of the Committee on Government Operations and Facilities. Today is Thursday, July 14th, 2022. The time is now 12:09 p.m. and I'm calling to order this public hearing of the Committee on Government Operations and Facilities regarding Bill 24-726, the Enhancing Reproductive Health Protections Amendment Act of 2022, and Bill 24-808, the Human Rights Sanctuary Amendment Act of 2022. Access to reproductive health care, including abortions, is a human right. It is also a DC value. In a moment, I'll talk about the various actions the council may take to strengthen our abortion protections, but first, I want to emphasize a very important point. Abortion access is already the law of the land in the District of Columbia. Our laws currently allow a pregnant person to obtain an abortion at any stage of the pregnancy. I know abortions invoke strong emotional reactions and spiritual concerns for many people, including some DC residents, and I don't mean to disrespect or trivialize anyone's beliefs or experiences. And in this hearing, witnesses should not demean, disrespect, or trivialize other people's positions. Out of respect for bodily autonomy and gender equity, our community has consistently chosen to keep the government from intruding into a pregnant person's decision-making around these important procedures. The U.S. Supreme Court's recent decision to overturn Roe v. Wade and cease to recognize a constitutional right to abortion has not altered the level of abortion access that exists under DC law for residents of the district. There is still cause for concern. If Congress decides to restrict abortion access in DC in the coming years, we would no longer be able to invoke Roe to challenge them. Congress already has demonstrated its willingness to take advantage of our lack of statehood and interfere with reproductive freedom in DC. Congress has prohibited us, but not the states, from paying for Medicaid beneficiaries' abortions using our own taxpayers' local funds. But for anyone who is listening and is afraid that their ability to obtain an abortion in DC is currently limited by local law, I want to assure you we have already made great strides to protect abortion access. Nevertheless, when a draft of the Dobbs opinion was published this May, I stood shoulder to shoulder with Mayor Bowser, Chairman Mendelson, Congresswoman Norton, and several council colleagues to declare that the district government will do what is within our power to strengthen abortion access in DC. The bills on today's agenda embrace those principles. The Enhancing Reproductive Health Protections Amendment Act, introduced by Councilmember Henderson with the support of 9 of our colleagues, expands on an existing law that prohibits the district government from penalizing people who seek abortions or harm their own pregnancies. The bill before us would further prohibit the district government from penalizing people who facilitate abortions or who make abortion products available for people to self-manage their own abortions. The Human Rights Sanctuary Amendment Act, introduced by Councilmember Nadeau with the unanimous support of the council, would amend the same statute and would prohibit the district government from facilitating interstate investigations and proceedings that seek to hold someone criminally or civically liable for various acts that are legal in DC, including providing or receiving abortions, providing or receiving gender-affirming health care, or engaging in same-gender sexual intimacy and relationships. In addition, in the event another state enters a judgment against someone for engaging in one of these protected activities in DC, the bill would allow the person to take the party responsible for the judgment to court in DC and be made whole. Now for a quick procedural note, these 2 bills amend the same underlying section of the DC Code. Specifically, we're dealing with a section that was added in 2020 into the Human Rights Act. The Human Rights Act is our local anti-discrimination law that is generally interpreted and enforced by the Office of Human Rights. Because the Committee on Government Operations and Facilities oversees OHR, Chairman Mendelson referred these 2 bills that amend the Human Rights Act for our consideration. Related, but not on the agenda today, I should note that I introduced 3 abortion-related bills that are pending before other committees. The Reproductive Health Care Insurance Coverage Expansion Act would require private insurers to cover abortion care with no out-of-pocket expense for the patient. That bill is pending before the Business Committee with comments from the Health Committee. I also introduced the Protecting Health Professionals Providing Reproductive Health Care Act, which would prohibit health professional licensing boards from taking adverse action against a DC healthcare provider for providing an abortion for a resident of a state where it is illegal. This bill is pending before the Health Committee. And I introduced the Medical Malpractice Clarification Amendment Act, which would prohibit medical malpractice insurers from taking adverse action against a DC healthcare provider for providing an abortion for a person who is a resident of a state where abortion is illegal. That bill is pending before the Business Committee. My hope is that we can get this entire package of bills, including those before us today, those I've introduced, and any others if they move soon, past this year. Today, we will be joined by Director Nin Kine, the Interim Director of OHR. I always appreciate Director Kine's thoughtful approach to policy and look forward to her testimony on behalf of the executive branch. In addition, because the bills have broader effects on the executive's relationships with the courts and even with other states, Attorney General Carl Racine has agreed to testify today. General Racine has an obligation at 5:30 today. So if testimonies are not, public testimonies are not done at that point, we will pause them to bring the Attorney General in. Judging by our witness list, the committee will also have the benefit of extensive input from members of the public as we consider how to move these important measures forward. To members of the public and representatives of the executive branch, I want to thank you for being with us today. I'm also grateful to have several of my colleagues, and right now, Councilmember Henderson with us for this hearing, Councilmember Janice Lewis-George as well. I just want to note that I said in my statement, I know that people have very strongly held positions on this issue, and we are committed to providing a public opportunity for open dialogue. I do want to note, though, that under Rule 322 of Council Rules, we will not allow threats of violence, excessive swearing, or attacks on the character of other witnesses or council members. So I would ask people not be engaged in that. If they are, then they will be removed from the hearing. With that, let me turn to my colleague, Councilmember Henderson.
Thank you, Councilmember White, and good afternoon. Good afternoon to you and Councilmember Lewis-George, and to all of the witnesses and individuals who are viewing today. I'm glad we're holding this discussion, holding this hearing to discuss reproductive rights, especially after the recent Supreme Court ruling overturning Roe v. Wade, which ended a right to privacy and abortion, which had been upheld for decades. I believe that Councilmember Nadeau's bill and my bill, the Enhancing Reproductive Health Protections Amendment Act of 2022, are both crucial pieces of legislation that take the necessary steps to reaffirming the district's commitment as a jurisdiction that values unrestricted reproductive health access. I'm going to talk mainly about the bill that I introduced and authored earlier this year, which would clarify that an individual assisting another individual who is seeking, inducing, or attempting to induce that individual's own abortion shall not be penalized. So that legislation deals mainly with self-managed abortions. And it clarifies that any individual's act of providing, dispensing, administering, or transferring possession of a product used for self-managed abortions should not be penalized. In the past year, as Councilmember White mentioned, we've seen unprecedented action against a woman's right to choose in states across the country. And this legislation, and I believe Councilmember Nadeau's legislation, was introduced in an effort to sort of respond to some of those things. And as much as we can. I think that we have heard not only from our mayor and our leaders and other council members, but the district sits in a very unique position, not having statehood, where we are left in some instances to the will of the Congress when it comes to these things. But for today And as long as we are able to move forward, the district will continue to protect women's access to reproductive health care. There was a study that was recently done called the Turnabout study, where researchers found that women already living in poverty who sought abortions, but were ultimately had to carry those unwanted pregnancies through, fell deeper into poverty, experiencing an increase in household poverty lasting at least 4 years relative to those who received an abortion. With close to 15% of DC's population living in poverty, according to the latest census data, the city's most vulnerable residents will be affected by any future reductions in reproductive care access. There's a long statement that my staff prepared, but I'm in the interest of time, because I know we have a lot of public witnesses today, and you mentioned, Councilmember White, that Attorney General Racine has a hard stop. So I will stop there. I look forward to hearing the witnesses today and plan to continue collaborating with my colleagues. Councilmember White, I appreciate the comment that you made at the end of your remarks. I always like to remind people that one of the joys of local government and the way that we organize in the Council of the District of Columbia is that we do allow for any person to sign up to testify, but that doesn't mean that we will just accept vitriolic rhetoric on the record. And so I hope that we can have a civil conversation today. But thank you in advance to all the witnesses for being here today. Thank you.
Thank you, Councilmember Henderson. Now I'm going to turn to my colleague who's a member of this committee, Councilmember Nadeau. Welcome.
Thank you, Chairman. Look, Dobbs v. Jackson Women's Health overturned 50 years of settled law and eliminated the constitutional right to an abortion. For the people targeted, there was no way to prepare for a constitutional right to be taken away. But the people doing the targeting had been preparing to ban and punish abortion for decades. And they were putting those plans into action before Dobbs even came down. On December 10th, 2021, the Supreme Court blessed Texas's 6-week abortion ban, which is enforced by a provision allowing private citizens to put bounties out on people who they believe facilitated abortions. In Texas, anyone who successfully sues an abortion provider, a healthcare worker, a member of the clergy, or anyone who helps someone access an abortion is rewarded with at least $10,000 in damages. Now 9 states have banned abortion, either in almost all cases or after 6 weeks of pregnancy, a point at which many people don't yet know they are pregnant. 4 states have abortion bans poised to take effect in the coming days, and 8 states have abortion bans on the books that have been blocked by the courts. In a longer statement that I've prepared for inclusion in the record, and which is now available on my website, I walk through exactly why this assault on reproductive freedom is unlikely to stop at state lines, why it's unlikely to stop at abortion, and why I drafted the bill I did, with the provisions and limitations I did at the time I did. For now, suffice it to say that I believe this bill, in combination with the legislation recently introduced by Councilmembers Henderson and Robert White, will robustly protect reproductive freedom and district values at a time when they have come under more vigorous attack than ever. If this legislation becomes law, the district government will be prohibited from cooperating with investigations attempting to impose liability for everything from receiving an abortion to getting your child gender-affirming care to living with and marrying the person you love. If you were to be sued under another state's bounty law, you could sue right back to collect the money you lost in the first lawsuit, and you'd continue to be safe here in the District of Columbia to live your life without fear. Know that for now, all of the things my law protects are legal here. It's safe and legal to get an abortion. It's safe and legal to buy and use and share contraception. And it's safe and legal to marry who you love and receive gender affirming care. This bill is just one tool in our toolkit to keep things that way. I want to say in closing that I look forward to hearing the testimony of our witnesses today, and I thank them for coming here to make their voices heard. I'd also like to thank Planned Parenthood, the National Coalition Against Domestic Violence, the American Civil Liberties Union, the Office of the Attorney General, the Council's Office of General Counsel, and Professor David Cohen of Drexel University School of Law. I'm confident that this bill is sound because of the work we did together before and after its introduction to get this right. And I look forward to hearing how we can make it even better and even stronger. Thank you, Chairman White. Thank you for moving to hold a hearing on this bill so quickly and for all the hard work of your staff. I look forward to the rest of this hearing.
Thank you, Councilmember Nadeau. Councilmember Lewis George, welcome.
Thank you. Thank you, Chairman White, for hosting this hearing and for your staff's hard work. And also thank you to my colleagues, Councilmember Henderson and Ado, for putting forth the legislation before us. And thank you to all the public witnesses joining us today, those in defense of reproductive health and justice. Thank you for the invaluable testimony you will provide today that will guide this council in better standing up for women, for reproductive freedom, for our LGBT community, for civil rights, and to say that we will not go back. In this city, in our city, we believe that every person has an inherent right to determine their own reproductive destiny. In our city, we do not and will not take away someone's consent to continue a pregnancy or become a parent. In this city, in our city, we believe contraception and abortion are healthcare, and we trust people to make the best decisions for themselves and for their families in accordance with their own values and beliefs. As DC residents, we know what it is to have the will and values of someone else imposed on us. And the Supreme Court's action to overturn Roe was a dual insult to us as DC residents. It invalidated individual liberties, and at the same time, it resubjugated the residents of the city to the whims of Congress that has proven time and time again uninterested and unwilling to affirm our basic equality as citizens of this country. In this city, we do government differently. We pass laws that value women, we affirm our transgender residents, we protect religious liberty, and we pass laws that understand that when someone struggles with a pregnancy, freedom and care is what they need, not judgment or barriers. If I sound upset today, I am furious that this is a conversation and hearing that needs to occur in 2022. But I am not deterred. In the absence of federal leadership, the district will once again step up and do everything we can to put our DC values into action. We will not go back. We will continue to fight. I am proud of the leadership of this city, from the executive branch to Eleanor Holmes Norton, our Congresswoman, to every member of this council, including Councilmember White, Councilmember Robert White, Councilmember Brianna Doe, and Councilmember Henderson for stepping up to the plate to protect our residents. So thank you all. I look forward to the conversation today.
Thank you so much. Before we get to our government witnesses, we will welcome testimony from members of the public. Everyone should have received a copy of the witness list yesterday. I'm going to call witnesses in the order they appear on that list. When I call you, the staff will promote you to witness. At that time, you can unmute yourself and testify. Heads up, when you are promoted, you will drop out of the hearing momentarily and come back in as a panelist. Public witnesses will be provided with 4 minutes to testify. Advisory neighborhood commissioners will be permitted with 5 minutes to testify. With that, let me welcome our first panel. We're going to do panels of 8 witnesses, although I'll need to call a few more people than that because some of our first witnesses are missing. Josiah Reedy, Ashley Carter, Camille Gales, Ebony Rose Thompson, Sarah Emerson, Jamila Parrott, Mary Carter Denny, Melissa Wasser, Tamika Auguste, Stephanie Black, and Serena Floyd, Dr. Serena Floyd. Josiah Reedy, welcome. You can begin your testimony when you're ready.
Good afternoon, Committee on Government Operations and Facilities members and staff. Thank you for the opportunity to testify regarding the legislation being considered today. I'll be clear about the perspective from which I'm approaching the issues presented by these amendment acts. I am unabashedly pro-life. I believe there is an overwhelming abundance of scientific, historical, and moral reasons to protect children who are still in the womb. And I am deeply saddened by the continued blindness of DC's leadership to the plight of the unborn. However, I'm also realistic. I expect the momentum of the larger conversation around abortions change not overnight, but rather gradually. Therefore, my intention today is to explain why, regardless of one's belief about the morality of or right to abortion, each of these acts is misguided and harmful. I want to begin briefly with the Enhancing Reproductive Health Protections Amendment Act. It focuses, of course, on so-called self-managed abortions. What's striking about that language is that the pro-choice movement is often centered on the need for open and available healthcare centers where women can receive purportedly safe care from a medical professional. DC has championed such abortion facilities and, when Congress has given us the chance, funded them. DC is now faced with a choice. Either groups like Planned Parenthood need our money and legal support, or women should just go ahead and handle abortion on their own. We can't say with one breath that abortions should take place in a supervised and regulated medical environment, and with the next that they should be unsupervised and unregulated in people's homes. I'm even more concerned, however, by the Human Rights Sanctuary Amendment Act. There are problems with the part of the proposed legislation that prohibits cooperation with other states' investigations and prosecutions. First of all, it infringes on the rights of conscience and religious liberty of DC's 36,700 government employees. Many of these employees would feel bound by duty or by conscience to cooperate with another state's legal processes. This legislation is explicitly designed to prevent them from exercising their beliefs in that way. Anyone who doesn't want to talk to police or lawyers in Texas, for example, is free, with or without this legislation, to not talk to them. So all this act does is shut the mouths of those who would otherwise feel compelled to speak. Second, I'm an advocate for DC statehood, but this kind of blatant extremism is what makes us a caricature in the eyes of the rest of the country and ruins the statehood cause. According to Pew Research Center, even 30% of Washingtonians aren't in favor of abortion being legal in most cases. This legislation is the kind that would only make sense if 99.9% of Washingtonians supported abortion. DC ought to act like the kind of accommodating and pluralistic city that we aspire to be and display that to a watching nation. Most importantly, the private right to action created by this act sets a terrible precedent. Let's imagine for a moment that DC had regulations forbidding MPD officers from using no-knock warrants, and that one of the mechanisms for enforcing this regulation was allowing for civil lawsuits, so a person or household against whom a no-knock warrant was used could recover damages from the offending officer. So imagine that an officer executes a no-knock warrant and shoots a man who believed in the officer to be an intruder, reaches for his firearm. I would say that West Virginia, hypothetically, has established itself as a sanctuary state for law enforcement officers' actions run afoul of regulations in their home state, not those of West Virginia. Let's say they established a private right of action for law enforcement officers to recover damages incurred in their home state. Let's say this officer who shot a man in DC flees to West Virginia. The family of the victim in this situation would, instead of getting justice, find themselves embroiled in a back and forth legal battle, might decide it's just not worth the fight. What went wrong in this hypothetical situation? Well, what went wrong was West Virginia's interference with the laws of DC. What went wrong was their hubris-ridden assumption that they knew better what was good for DC than Washingtonians did. Let's not make the same mistake. Let's strive for laws that both reflect what Washingtonians want and allow us to work peaceably and cooperatively with the people around us. I urge you to respect the laws of other states as we would want them to respect ours, and to reject this attempt to make other states' rules for them. I'm happy to discuss this legislation further. Thank you very much for your time.
Thank you very much. Ashley Carter, welcome.
Thank you, Chairman White, and thank you to the committee for the opportunity to provide testimony today. My name is Ashley Carter, and I'm a managing attorney for the DC Volunteer Lawyers Project. DCVLP is a nonprofit organization here in the district that was established in 2008 to provide direct legal and advocacy services to low-income survivors of domestic violence, at-risk children, and other vulnerable individuals. We believe that a life free from violence and abuse is a basic human right, and we work to reach this goal through direct legal services, advocacy, training, and outreach. DCVLP attorneys provide survivors of domestic violence with trauma-centric representation in civil protection order cases, family law matters, and immigration cases. We also provide advocacy regarding victims' legal rights in related criminal proceedings against their abusers, housing, employment, and public benefits matters. And we represent at-risk children as guardians ad litem in contested custody matters. Now, when we think of domestic violence, I think most people picture physical violence, and that makes sense. We know that 1 in 4 women and 1 in 7 men have been victims of severe physical violence by an intimate partner in their lifetime. But while physical violence is certainly a common form of abuse, domestic violence is actually a larger pattern of control and coercion that can manifest itself in numerous ways. And that pattern can include mental abuse, emotional abuse, financial abuse, and reproductive abuse. And in fact, many of DCVLP's domestic violence clients have experienced all of those types of abuse within their relationship. Numerous studies have demonstrated the connections between intimate partner violence and reproductive abuse. We know that there are negative physical, mental, and sexual and reproductive health effects that could include unintended pregnancies, miscarriages, stillbirths, and intrauterine hemorrhage. All of those have been linked to intimate partner violence. There are studies that show that 35% of women who reported partner violence also reported some form of reproductive control or coercion. We also know that sexual assault is an enormous problem for our clients. And according to the CDC, 1 in 5 women in the United States has experienced rape in their lifetime, and 2.9 million of those women have experienced a pregnancy related to that rape. There are similar studies that show that 77% of those rape victims reported that they were raped by a current or former intimate partner perpetrator, and 30% of those women experienced some form of reproductive coercion by the same partner. Finally, we know that pregnancy itself is a risk factor for violence, and pregnant women in the United States die due to homicide more often than they die of pregnancy-related causes, and often they are killed by their intimate partners. As the committee is aware, the Supreme Court's recent decision in Dobbs v. Jackson Women's Health has upended one of the essential tools that we know survivors rely upon to ensure their own safety and health, abortion. And we know that the concurrence filed by Justice Thomas makes clear that other substantive due process rights, including the right to access contraception, may also soon be at risk. The bills that are before the council today do ensure that survivors of domestic violence have meaningful choices when determining whether or not to consider and continue a pregnancy that could place them in serious danger. And that's particularly true given the negative medical outcomes that can be associated with intimate partner violence. So the bills that are before the committee today ensure that women across the country can access abortion and access contraception within the district, even if it is not available in other states. And it also ensures that women can seek this care without fear that they will be investigated or prosecuted for choosing to do so. It also protects the doctors in the district who provide care to these patients. We think that these bills are essential. I thank the committee for considering them, and thank you for your time today. I welcome any additional questions you may have.
Thank you very much. Our next witness is Sarah Emerson.
Good morning. Good afternoon, members of the committee and chairman. Thank you, Councilmember White, Henderson, Nadeau, George, to each council member who introduced this legislation, and for the complementary legislation, which you just explained, which expands upon these two bills. I have thrown out my notes. You have my written statement. Thank you for the opportunity to speak today. My name is Dr. Sarah Emerson. I'm a board certified OBGYN and clinical professor at GW Medical School. I'm chair of the DC section of the American College of Obstetricians and Gynecologists, whom I represent today. For over 35 years, I've lived in Ward 3, and until 2015, I practiced general OBGYN in Foggy Bottom. I now provide abortion care at several area clinics. I see many friends on this list of speakers. My colleagues, I'm going to get emotional, who provide abortions at local clinics, professors of OBGYN, my rabbi from Temple Sinai, my neighbors, parents of my children's school friends, many lawyers from national civil rights organizations I know. Hello, Jamila, Tamika, Serena, Hannah, Karen, Cleo, Karishma, and many others whose names I haven't added to this list. You all know what Dobbs did. And we all know what we have to do here in DC. In addition, ACOG has released with 50,000 members nationwide and released a document which was co-signed by 75 respected mainstream healthcare organizations opposing legislative interference in the patient-clinical relationship. The statement highlights the dangers of banning appropriate medical care and the erosion of trust between patients and clinicians. DC can and must mitigate the dangers of our post-Roe world. Thank you for addressing these issues. Specifically, self-managed abortion is proven safe, highly effective, and the World Health Organization calls it self-care intervention, making access more equitable. People choose self-managed abortion on their own without a clinician for many reasons, including long wait times for appointments, logistics, cost. Some people consider it more humane and more private. We know that people will face consequences from restricting abortion with an increase of pregnancy-related deaths by 20 to 25%. Black maternal mortality alone will rise by 1/3. Substandard medical care is unacceptable by all of us. We have a moral and professional obligation to provide quality without government interference. And we are glad to see that the DC Council will present the mayor with clear legislation to protect the reproductive rights of DC residents and those who travel from abortion hostile states. My patients, all patients are individuals, whole, complicated, and intersectional people. Everyone is entitled to dignity, autonomy, and the agency these bills support. Physicians like me should not fear arrest, prosecution, and potential incarceration for doing our work and providing necessary, expected, high-quality health care. Patients, clinicians, staff, and supporters must be clearly protected from legal retaliation. In sum, abortion is safe. Self-managed abortion is safe. People denied abortion are at increased risk for pregnancy complications, including maternal and neonatal death. Restricting access to abortion makes abortion dangerous. The DC section of the American College of Obstetricians and Gynecologists, the doctors who deliver most of the babies in DC and provide most of the mothers with healthy children, supports all the legislation you are introducing to protect those who can make their own decisions about how to manage any pregnancy protection, and how they live their lives. Thank you very much for extending the protections to clinicians, supporting staff, friends, and family from the District of Columbia and beyond. Thank you for your time. Any questions?
Thank you very much. Our next witness is Mary Carter Denny. Welcome. Doctor.
Thank you for having me. My name is Dr. Mary Carter Denny, and I've been a resident and homeowner in the District of Columbia for nearly 10 years. I come to you today first as a parent, then as a woman, and finally as a physician. I'm the mother of an incredible 15-month-old child named Julian. In late 2020, I felt very blessed that my husband and I were able to get pregnant and very excited to meet our baby. It was a mostly uneventful pregnancy until my third trimester. I had life-threatening complications at the time of his delivery and in the postpartum period. I consider myself incredibly fortunate to be alive today, thanks to the access to excellent medical care and unwavering support from family and friends. I cannot even imagine the pain and despair of going through what I did had my pregnancy been unplanned or unwanted. We must do everything in our power to uphold women's health and reproductive rights. As a woman, I know firsthand that pregnancy, delivery, and postpartum are extremely challenging, both physically, emotionally, and financially. Women and all birthing parents deserve the right to be in control of their own bodies, their own health, and indeed their own lives. I recognize that my education, my race, and my income gave me incredible privilege in accessing prenatal care, as well as advocating for myself and for my son before, during, and after birth. When abortion access is denied, people of color and low-income individuals suffer the most. It is imperative that we protect reproductive rights and support all people in accessing affordable and safe medical care, which includes abortion. The decision to continue a pregnancy and become a parent is very personal. That decision lies with the pregnant person, their partner, and their medical providers. There is no place for lawyers, social media influencers, or other people in the decision regarding whether a pregnancy is continued. As a physician, I'm in staunch opposition to denying medically necessary treatment, which includes abortion, to any patient. It is heartbreaking and truly horrific to hear the accounts of physicians having to delay or deny medically unnecessary abortion care since Roe versus Wade was overturned. By now, you have all read about the many instances where physicians from Texas to Ohio are forced to consult their hospital's attorney for hours to avoid losing their medical licenses, and in so delay their patients' life-saving abortion surgery for instances such as an ectopic pregnancy. You have also heard the stories of women being forced to continue pregnancy when the baby has known lethal fetal anomalies. Essentially, they are forced to carry a very sick baby for months just to watch it die at the time of delivery. This is simply unthinkable and cruel. Fortunately, we now have the opportunity to protect and support access to women's health, which includes abortion care here in the district. Now that Roe has been overturned, it is even more important for the district to protect access to care and protect providers themselves from criminalization and discrimination. I strongly encourage members of the council to vote to pass this bill immediately. Thank you for your time and consideration.
Thank you very much. Jamila Parrott, welcome. I'm sorry, Melissa Wasser.
Chairman White and members of the committee, good afternoon. My name is Melissa Wasser, and I am a policy counsel at the ACLU of the District of Columbia. ACLU DC is committed to upholding the rights of individuals to decide freely without governmental hindrance or coercion, whether or not to bear a child. In light of the Dobbs decision at the United States Supreme Court, it's extremely important to enshrine more reproductive justice rights into our laws, and we are grateful that the DC Council has chosen to take that crucial step today. We support the two bills before the committee today as important measures that will help protect the right to access safe, legal abortion and other reproductive health care in the district. If passed, Bill 24-726, the Enhancing Reproductive Health Protections Amendment Act, would expand protections to those who assist a person seeking an abortion. This bill will help protect patients in DC seeking reproductive health care, regardless of what they are doing, whether they are doing so in a healthcare setting or self-managed at home. Access to reproductive care, including care outside of the traditional healthcare system, is among our most fundamental rights. This bill is especially critical now, considering the criminalization of reproductive health care sweeping the country after the Dobbs decision. However, the bill's protections do not currently extend to organizations and groups of individuals who assist with abortion access, but do not provide professional healthcare services in the district, including nonprofits and abortion funds that provide support through financial, logistical, or other means. We recommend that the bill be amended to ensure these groups are also protected. The ACLU of DC also strongly supports Bill 24-808, the Human Rights Sanctuary Amendment Act, for its efforts to expand protections to other legal issues impacted by the Dobbs decision, including reproductive justice, the right to contraception, and marriage equality. We also support this legislation because it seeks to eliminate barriers that transgender and queer people face in receiving healthcare, including treatments specifically related to gender transition and gender affirmation. The new Section 105B of this bill creates a private right of action under DC law, intending to address the harms resulting from out-of-state judgments. We appreciate that the council is establishing itself as a national leader in the fight for reproductive justice, and we share that goal. As it is currently drafted, however, we are concerned that the provision of the legislation may be open to constitutional challenges based on the full faith and credit clause of the United States Constitution, which requires recognition and enforcement of out-of-state judgments. To prevail on a claim under this provision, a person would have to demonstrate that a court in another jurisdiction entered a judgment against them for obtaining covered services or engaging in protected conduct in the district. The person then may recover just damages, including damages in the amount of the judgment in the other jurisdiction, plus costs, expenses, and reasonable attorney's fees spent in defending that action, along with costs, expenses, and reasonable attorney's fees incurred in bringing the action in DC. While this is new constitutional territory post-Dobbs, we recommend the council revise this provision to ensure that the final legislative language is clear about respecting the validity of foreign judgments when creating a private right of action under DC law. We stand ready to work with the council and our advocacy partners to provide updated language before the markup of this bill. We are at a critical moment to advance abortion and healthcare access for the district. The Dobbs decision will cause and has already caused suffering for millions of people throughout our country. As the district is working towards a more racially equitable and just future, we remind the council that the brunt of criminalization in these laws lies on the shoulders of our Black district residents. The ACLU of DC hopes to work with the council to tackle harmful criminalization systems that still exist in the DC Code, both within and outside of the reproductive justice context. Thank you for allowing me to testify here today, and I'm happy to answer any questions you may have.
Thanks so much. Tamika Auguste. Doctor.
Good afternoon, Chairman White and members of the Committee on Government Operations and Facilities. Thank you for allowing me the opportunity to testify on behalf of MedStar Washington Hospital Center in support of the Enhancing Reproductive Health Protections Amendment Act of 2022. This bill amends the Human Rights Act of 1977 to include protections for persons who assist and support others with self-managed abortions outside the healthcare system. As an obstetrician gynecologist practicing in Washington, D.C., I have dedicated my career to ensuring the delivery of equal and evidence-based healthcare to my patients. I am the current chairwoman of Women and Infant Services at MedStar Washington Hospital Center and the regional director of the Washington, D.C. Women's Health Service Line for MedStar Health. MedStar Washington Hospital Center has more than 50 OBGYNs and other allied health professionals dedicated to delivering evidence-based healthcare here in the District of Columbia. We are concerned that the recent Supreme Court decision overturning Roe v. Wade has left many patients and healthcare providers in danger of being threatened, harassed, intimidated, or perhaps worse. We know that even prior to the recent Supreme Court decision, the District of Columbia was already seeing individuals seeking quality and comprehensive medical attention for pregnancies fleeing from states with a more restrictive environment for reproductive services. In 2019, 68% of the abortions performed in DC were for patients who were not district residents. Now that the legality of abortions is up to individual states, we should be prepared and expect the number of people coming to the District of Columbia for reproductive services to increase. Public officials in several states have already indicated they want to prohibit individuals from their state from traveling to another state for these services. Several have indicated they want to ban or severely restrict access to medication for reproductive health care. And some want to criminally punish individuals who assist those in seeking abortions and other reproductive services. As a result, we are bracing ourselves for a strain on our reproductive health delivery infrastructure here in the district. While we are happy to step up to meet the increased demand for these services, the city's dedicated providers need these protections to do so. This bill will help ensure security and access to care by first protecting those who assist in the delivery of reproductive health. Thank you for the opportunity to comment and participate in this important legislative hearing.
Thank you very much, Doctor. Is your last name pronounced Auguste?
Auguste, yes.
Okay, thank you.
Thank you.
Stephanie Black, welcome.
Hello. Thank you, Chairman White and the DC Council for allowing me to add my testimony to today's important hearing. My name is Steph Black, and I'm an abortion activist and writer here in Washington, DC. Since coming to DC in 2015, I've done a myriad of work relating to self-managed abortion and abortion access. My undergraduate thesis at American University centered on the need for the abortion rights movement to include self-managed abortion in our advocacy. I was trained by SAS USA as an abortion information educator, as a self-managed abortion information educator, and have personally educated dozens of people on the history, protocol, and landscape of self-managed abortion in America. On a regular basis, I receive direct messages on my various social media channels from people who are seeking information about self-managed abortion or supporting a loved one through self-managing an abortion. I'm also a Plan C fellow and ambassador. I'm a practical support volunteer, which means I drive patients coming from all over the country to abortion clinics in and around Washington, D.C. I cannot express strongly enough the importance of being a reliable presence for abortion seekers, whether they come to me via social media or through practical support collectives. As states all across the country continue to roll back abortion rights, the need for accurate information, support, and community care has skyrocketed. While many people traveling for abortion care cannot bring their community with them, it's an honor to be able to fill that role, even for a little while they access the abortion care they need here. But not everyone is able to travel for abortion care. For those who self-manage their abortions in the privacy of their own home also deserve support and respect from those who can give it to them. I have filled both of these roles. As someone who has facilitated out-of-state travel for abortion seekers and someone who supports those self-managing their abortions. Sometimes this work scares me. As much of an honor as it is to be trusted to hold space for abortion speakers in both of these capacities, the current political climate around abortion has never been more hostile. But the risk surrounding abortion is not a medical one, it is a legal one. Those having abortions should not have to do so alone, but those who aid them shouldn't also have to worry about their legal risk. Everyone deserves to have an abortion with respect and dignity, and criminalizing the people who facilitate them is wrong. When I offer information and support for abortion seekers, my focus should solely be on them, not whether or not I too could be prosecuted for the role I have played. I, like many activists and volunteers I know, are going to continue to provide this kind of support regardless of the legal risk it presents to us. These two amendments are critical to protecting not only our well-being, but the well-being of the abortion seekers we aid. I urge you to pass the Enhancing Reproductive Health Protections Amendment Act and the Human Rights Sanctuary Amendment Act of 2022. Thank you very much for your time.
Thank you. Dr. Serena Floyd, welcome.
Good afternoon. Thank you for the opportunity to provide testimony on this important legislation. My name is Dr. Serena Floyd, and I am the Vice President of Medical Affairs and the Medical Director at Planned Parenthood of Metropolitan Washington, D.C. I am a board-certified obstetrician gynecologist and have been providing reproductive health care for over 20 years. I have an MPH in maternal and child health from the School of Public Health at the University of North Carolina at Chapel Hill, am chair of the American College of Obstetricians and Gynecologists Committee on Healthcare for Underserved Women, and have done work to improve maternal and infant health in Haiti and in Ghana. I testify in support of the two bills before the committee today, the Enhancing Reproductive Health Protections Amendment Act and the Human Rights Sanctuary Amendment Act of 2022. I thank Councilmembers Henderson and Nadeau for their leadership in introducing these bills, and Chairman White for bringing them quickly to a public hearing. I also thank the many council members that have signed on as sponsors or co-sponsors. The reproductive rights landscape in this country changed unthinkably in the last few weeks with the Supreme Court decision in Dobbs v. Jackson Women's Health Organization. Now that decisions about abortion have been left to the states, policymakers who live in states where abortion remains legal must take up the mantle of protecting patients and the providers who deliver their care, which both of these pieces of legislation aim to do. As a longstanding provider of sexual and reproductive health care services in the region, this is not theoretical for PPMW. Our ability to serve our patients and to ensure their continued access to abortion and other reproductive health services depends on having policymakers who will stand with us and pass protective legislation like the two bills being heard today. The first of these two bills, the Enhancing Reproductive Health Protections Amendment Act, expands the Strengthening Reproductive Health Protections Amendment Act of 2019, which protects DC residents' rights to make their own decisions about their reproductive life choices and prohibits penalties for people who self-manage their abortions. PPMW was proud to join coalition partners to work on this legislation and was thrilled when this protection was secured in the DC Human Rights Act, as we saw where the nationwide attacks on reproductive rights were heading. The legislation being heard today critically expands these protections to include those who support individuals self-managing an abortion and those who assist with acquiring the means by which to self-manage an abortion. People elect to self-manage their abortions for various reasons, but for many, the barriers to care they face are often a primary reason they seek this option. As people have more and more questions about the legality of abortion, we can expect self-management to be chosen even more frequently. It is imperative that DC ensure through protection from penalties that those who opt to self-manage their abortion and their helpers are not criminalized for their decisions. The second bill under consideration today, the Human Rights Sanctuary Amendment Act of 2022, seeks to protect DC residents, including providers who engage in conduct protected in the district that is now or may soon become illegal in other states. This includes seeking, receiving, using, and providing contraception, seeking, receiving, and providing an abortion, and providing or receiving gender-affirming care. The bill prevents district officials from cooperating with any out-of-state investigations or proceedings into these types of actions. The bill also creates a private right of action against parties who successfully bring Texas SB 8-style bounty claims for engaging in conduct that is protected in DC. PPMW supports this bill as an important protection for our providers, patients, and patient support networks against overzealous efforts of other states to enforce their new laws, which are at odds with DC laws and values. As an abortion provider who works alongside other abortion providers and support staff at our health centers, this legislation directly impacts my ability and the ability of my team to do our work. You have heard previously that in 2019, DC had more out-of-state residents obtaining abortion than any other state in the country, and that was before Roe v. Wade was overturned. At PPMW, we have already seen patients traveling to us from various areas, and our providers, our staff, and our patients are aware of what's happening around the country, and it's leading to questions about the risk for them to provide this care and to receive this care. So I want to be able to reassure them that here in the district, those are worries they do not need to have. So I thank you very much again to the council, to council members Henderson and Nadeau for your leadership in sponsoring these important bills, and to Chairman White for holding this hearing.
Thank you very much. Given the subject matter here, obviously much more directly impacts women, and two of the authors of two of the bills are here with us. So let me turn first to my colleagues, starting with Councilmember Henderson, if you have questions for this panel.
Oh, Councilmember White, I was not expecting this. Good afternoon, everyone, and thanks to all of the witnesses who testified. I want to say a special thank you to Dr. Emerson, Dr. Denny, Dr. Auguste, and Dr. Floyd for the work that you all do, and also, to Steph Black as well for the work that you do to support individuals who are seeking abortions. I'm going to ask a couple of questions kind of focused on the first bill. If any of the doctors are still here, this is a question okay, great, Dr. Auguste, that works. All right, Dr. Floyd, all of you are here. Okay. So, one of the things that when thinking about self-managed abortion, and again, this was my office introduced this legislation way before the Dobbs decision, right? This bill was being introduced because I was watching sort of the conversation that was happening in other states, but also realizing that, there are a lot of people who don't have to go physically into a doctor's office or physically into a clinic in order to, have an abortion or terminate a pregnancy. But I think there's also, I guess now, because I have two kids, so women of a certain age, my girlfriends and I talk about these things all the time, but a lot of people don't realize that there are women who have pregnancies who they very much wanted, who choose to go the self-managed route, as opposed to a spontaneous, is that what they call it? Spontaneous miscarriage, or a miscarriage that they know is likely to happen, but they want to be able to sort of control it, the time and environment. Am I making sense here?
Get it over with.
Yes.
Yeah, I think what I'm hearing is that these are folks that want to be able to, as you said, have control, have some personal autonomy, have the ability to make the decision, and have the ability to be able to go through the process in a location and a manner that allows them to be comfortable and to feel as though they have, their ability to make their own decisions are respected. And so I'm guessing that the question about self-managed abortion is kind of similar to that, like why people may opt to self-manage,
right.
Instead of going into a provider's office. And it's for some of the same reasons, whether it's privacy, because they just want to have the privacy of being able to do it at home, because they don't want to have to deal with protesters that they'd have to pass through in order to get into a clinic, because they want, again, to have that autonomy and agency, that control over the process, convenience, not having to take time off of work and arrange childcare and find transportation to get into a health center. And it's empowering. It's empowering to be able to self-direct your care. And so those are some of the reasons why I think people may opt for the self-managed option, even sometimes if they have the ability to go into a health center. Does that answer the question?
Yeah, no, that definitely does. And I mean, Dr. Emerson, I know you sort of mentioned, to get over with. I had a friend of mine who, she had already had a miscarriage, was pregnant again, very much wanted the pregnancy, but I think there were complications. And so her physician said, it is likely you are going to have a miscarriage again. And she made the decision of, okay, I prefer to control this as opposed to going through, what had already happened before, which was traumatic and traumatizing for her. And so, got a prescription, went to the pharmacy to fill the prescription, and actually was questioned by the physician. This was not in the District of Columbia. This was in another state that has some interesting situations there. But I think it's often that people forget it is not just about unwanted pregnancy. There are other reasons as to why individuals need access to this type of care.
Thank you, Councilmember Henderson. Dr. Floyd really explained the details much better than I did, but I'm sorry for your friend. And I guess I felt the emotion that you felt, that so many people felt, that she wanted to take control and get it over with in her life. That miscarriage management and abortion care, induced abortion care, have been studied more than any other medical procedure just to prove how safe it is. I mean, you're 17 times more likely to die in childbirth. Why should somebody die from a fetus that won't survive, for example, or go through a miscarriage all of a sudden at the mall instead of at home? So thank you for recognizing it. And thank you, Serena, for going through all the better than I did.
Yeah. No, I think, Dr. Emerson, I think you highlighted a real important take-home point. And I think just to add to what you mentioned, the process, the actual physical process is the same. So whether it's a miscarriage or if it's someone who's self-managing an abortion or, having a medication abortion that was prescribed to them in a doctor's office, the actual physical process is the same. So being able to have control, regardless of what the reason might be, whether it's a loss or it's an abortion, should also be similar, and that people in all circumstances, individuals should have the right and the ability to be able to control the process as long as it's going to be done in a manner that's going to be safe and respectful.
Right. Steph,
Serena, you brought up something else. Oh, I'm sorry. And that was that, medication abortion, it's actually better to use the medication for medication abortion, both medications that are used, than the one that had been used for a while. It's better for patients, and it's hard for patients to get that medication here in the office of their own gynecologist, because they have to, some pharmacists can't prescribe it. You have to sign up to be able to dispense it. There are still restrictions.
Right. I'm running low on time, but Ms. Black, I see that you had your hand up, and I, as someone who has assisted individuals in terms of self-managed abortions, I give you my last little 15 seconds.
Thank you. I'll try to make this quick. And I want to thank all of the medical providers who are here, but also wanted to uplift that self-managed abortion is specifically referring to the people who have an abortion outside of the medical care system. They either cannot access a clinic because they can't access the travel. They live in a state where it's not legal to have an abortion anymore. They cannot get the child care in order to cover the length of time they'll need to actually travel out of state to a state that might have a waiting period. There are a lot of reasons based on identity why certain people aren't comfortable in a medical setting. They might be undocumented. They might have faced history. They might have histories of traumatic experiences at the hands of medical care providers, such as queer people and people of color. And I just wanted to uplift that there are lots of reasons why people might not actually be comfortable or able to get through the doors of a clinic in order to self-manage their abortion. And sites like Aid Access and Plant C Pills are really great resources for those folks who aren't able to get across the threshold of a clinic.
Thank you. Thank you, Chairman White.
Thank you, Councilmember Nadeau.
Thank you, Chairman White, and all of our public witnesses today. I don't have any questions for this panel, but I do appreciate you all taking the time to come out and testify so that we can move forward with a full record on these bills. Thank you.
Thank you. I don't think Councilmember Louis George is with us now. So just a couple questions for this panel. One, I wanted to make sure, Dr. Auguste must have known I was coming to you. I just want to confirm something that I think I heard in your testimony, but prior to Dobbs, 68% of abortions in DC were for people who are not residents. Is that right?
That is correct. In a study in 2019, the Schumacher Institute was able to provide the data to show that 68% of the abortions done in 2019 were from residents that were not of the District of Columbia.
Do you know, have thoughts on why that is?
I think from existing pre-Dobbs, even the existing laws that were there, and knowing that the process and the infrastructure that we do have here in the District of Columbia is highly regarded and compared to some other cities.
Okay, I appreciate that. Melissa Wasser, you mentioned something in your testimony that I wanted to follow up on, concern about respecting validity of foreign judgments. Can you talk a little bit more about that?
Yes, absolutely, Councilmember. Thanks for the question. Just before I answer, I just do want to point out this is a new area of the law post Dobbs. I think a lot of groups are really re-examining in light of Dobbs what this means. And I just want to be very clear for you and for the record. We are not saying that creating a private right of action would be impermissible, but rather the current language may be subject to a challenge under the full faith and credit clause. And we want to raise that concern here because we want to make sure that DC is in the strongest position possible to further this laudable public policy goal of addressing these harms. And also ACLU DC and our thought partners, we're here to be a resource to work with you and the committee to update the language, specifically around the private right of action. We want to ensure that the language addresses the harm resulting from out-of-state judgments, but doesn't nullify or stop the validity of other judgments in other jurisdictions. So as it currently stands, I know we've mentioned the bounty laws in other states. If a person in another jurisdiction, would sue me under the bounty law for assisting somebody to travel to get an abortion, they get a judgment against me. I think a number that was used was $10,000. If the person then would come to DC to register that out-of-state judgment, we are unsure, if this bill as written, if I get a $10,000 judgment and it offsets the judgment in the other jurisdiction, if a court could interpret that that practical effect as nullifying the judgment again. So we just want to make sure that DC is in the strongest position possible, especially after Dobbs. A lot of states, we worked with the ACLU of Connecticut and some other folks in other states to, review the language. But again, we want to make sure that you and the council are in the strongest place possible. And we think that we can be there and help you get there.
I appreciate that.
Thank you.
Steph Black, quick question. I think if I followed your last question, your answer to Councilmember Henderson's last question correctly, you do assist at least some people out of state. What, if anything, are you seeing that's different now than before Dobbs?
Yeah, I will say almost all of the patients that I drive are people traveling from out of state. Some are more local, coming from deeper parts of Virginia or Maryland, but I have assisted people who travel from as far as Chicago. And I'll say that every email request that we get now comes with a warning that says this person is traveling from a state where there are restrictions on abortion, and please take this into consideration when you are signing up for a shift or you're signing up to assist someone. So this is a legal risk that I myself as a driver am considering, and it's something that's weighing heavily on patients who are traveling to DC. DC, the DMV area in particular, has two of the very few clinics that will provide abortion throughout pregnancy, which has made DC a hotspot for abortion care pre-Dobbs, and that will only continue to deepen, and that will only continue to make DC more of a place for people to travel to. And the patients that I've seen are scared and are nervous, and being able to fill that role as somebody who can step in and provide a shoulder to lean on and just a friendly face has been really, really critical for not only me, but for the people I talk to.
Appreciate it. Well, I really want to thank this panel. I think we may be calling on some of you as we work through this legislation and work to get it to a markup. So again, thank you so much for the work that you're doing. Thank you for being with us today. And we will move to our second panel. Dr. Jamila Parrott, Hannah Goldstein, Stephanie Russell, LaDon Love, Karen Mulhauser, Judy Waxman, Alex Stein, Herb Garrity, Michael New, Heather Schumacher, and Cleopatra McGovern. Dr. Parrott, if you are here, you can turn on your camera. Welcome.
Hi, thank you. Thank you. It's wonderful to be here. Thank you so much for allowing me the opportunity to testify. My name again is Dr. Jamila Parrott. I use she, her pronouns. I am a board certified, fellowship trained obstetrician and gynecologist. And in addition to having a comprehensive background in family planning and reproductive health, I'm the president and CEO of Physicians for Reproductive Health and an abortion provider here in my hometown, the District of Columbia. It's a privilege to provide care and to serve the community that made me who I am. I'm here today to talk with you about the safety of self-managed abortion care and also the harms of criminalization. We're really at a critical moment for access to reproductive health care right now. The Supreme Court's recent ruling to overturn and eliminate the constitutional right to abortion for millions of people in this country demands bold and proactive solutions. The district must do everything it can to provide protections to people seeking abortion care, to those providing abortion services, and including protecting those who are self-managing their abortions from the risk of criminalization. Reproductive justice, ideated and articulated by 12 Black women in 1994, asserts that every person has the human right to personal bodily autonomy, to have children, to not have children, and to parent the children we have in communities that are safe and sustainable. As a doctor and a Black woman and a mother myself, the principles of reproductive justice resonate to my core and are the foundation of the medical care I provide. When I think about the care my community needs and deserves, I know that access to abortion is an essential component for living a healthy, dignified, and free life. When someone decides to end a pregnancy, whether they go to a healthcare provider or manage their own abortion, they should be able to do so safely and with dignity and without fear of jail or arrest or investigation. And people have been self-managing abortion care for as long as abortion has existed. And with the constitutional right to abortion eviscerated and abortion bans and restrictions implemented across the US, more people will need access and support in self-managing care. We've already heard from previous panelists that self-managing an abortion with pills can be a safe way to end a pregnancy, particularly when people have access to the information and the resources that they need. We know that the medications many folks use, mifepristone and misoprostol, are FDA approved and have been approved, and mifepristone in particular for clinical use since 2000. And in April of 2021, the FDA removed their longstanding requirement for mifepristone to be dispensed in person. This change supports the clear science and consensus of the medical community that mifepristone is safe and that barriers to access are medically unnecessary. These FDA-approved medications can be sourced online or elsewhere. We've also heard that in a previous panel from organizations like Aid Access. Research suggests that misoprostol used by itself or in combination with mifepristone is also safe and an effective way to end an early pregnancy, especially, as I said, when folks have information that they need. As we sit in this complicated and ever-changing landscape for abortion care, health providers are concerned about our ability to share information and resources with our patients. Our community deserves access to medical resources and support from providers without the fear or threat of criminalization. Just as patients should not fear criminalization, providers should not fear criminal or civil retaliation for providing this safe and essential care. When the government usurps or limits a person's ability to decide for themselves whether or not to obtain an abortion, they are disrespecting our autonomy and making it clear that they do not trust us to make decisions that are best for ourselves and our families. Abortion is a health issue, not an issue for the criminal legal system. And DC has an opportunity to protect its residents' access to abortion care. I urge the support of Bill 24-726 and Bill 24-808 to protect abortion access and those accessing it before it deteriorates further. Our friends, our families, our patients, and our communities depend on it. Thank you so much for the opportunity to testify today.
Thank you very much. Hannah Goldstein, welcome.
Good afternoon, Chairman White and members of the DC Council. And I'm humbled to be here with such an incredible group of doctors and advocates who are also testifying. Thank you for for allowing me to speak with you today. I'm Rabbi Hannah Goldstein. I'm serving in my 10th year as a rabbi at Temple Sinai in Ward 4. I join you today to speak in support of the Enhancing Reproductive Health Protections Amendment Act of 2022, as well as the Human Rights Sanctuary Amendment Act of 2022. I feel called to add my voice to a debate in which people of faith are often at the center. I speak from the Jewish tradition, a tradition that is clear about the necessity of abortion access. Jewish sources going back to the Hebrew Bible are clear and consistent about the fact that Judaism does not believe that life begins at conception. Our legal texts are clear that the fetus is considered a part of the person carrying it, not a life unto itself. And if the fetus poses a threat to the life of the pregnant person, then the pregnancy must end. Judaism values life above all else, and family is at the center of Jewish practice, but our reading of sacred text is fundamentally different from those who have successfully enshrined their religious beliefs into law in many parts of this country. My own commitment to these issues is deeply grounded in my Judaism, yet no one's personal views should translate into policies and laws that strip individuals of their autonomy and right to make personal decisions. In light of the Supreme Court's overturning Roe v. Wade, the District of Columbia must continue to do everything in our power to provide a safe haven for those who seek to have an abortion and those healthcare professionals who are able to provide them with care, be it in person or via self-managed abortions. Rabbi Mindy Portnoy, my predecessor at Temple Sinai, testified before the Senate Judiciary Committee in 1981. And I'm sad that we are still having these conversations. She said, "I strongly suggest that Jewish religious teaching is perfectly valid and does not suggest a lesser morality or less respect for human life than other religions. In order to provide care to those who seek an abortion as a matter of religious freedom, and for anyone else who turns to DC as a source of this basic health care, and for the providers who continue to provide this care, I testify in support of B 240726 and B 24808. Thank you.
Thank you very much. Next witness is Stephanie Russell.
Chairman White and council members, good afternoon. My name is Stephanie Russell and I'm a resident of DC. I have serious concerns about the health and safety of women because of the bills proposed today, especially as regards medication abortion or self-managed abortion. The proposed bills seek to shield from consequence non-medical persons who distribute abortion medication from DC into other states. The law exists, among other things, to protect the lives of its citizens. If signed into law, B 240726 and B 240808 will endanger women. With these bills, a boyfriend, a friend, a parent, a complete stranger, an abusive partner, a sex trafficker can acquire and distribute medication abortion to a woman who never met with a doctor, a nurse, or even a trained clinic director on a telehealth call. Is this the standard of healthcare we promote in DC? I can't get an antibiotic without seeing a doctor. How can we take seriously that abortion is healthcare or that this legislation is about the rights of women when the legislative priority is not on the health of women, but on any non-medical person who has the means and desire to distribute medication abortion? Is a person who travels to DC to obtain these pills or the person who mails them without ever having met the woman, is that person medically qualified to determine if the woman is a good candidate to receive the medication? High blood pressure is a contraindication of mifepristone. Are we to assume that non-medical professionals are taking blood pressure before they hand out these medications and asking about other contraindications, like if she's on steroids or blood thinners or has a blood disorder? And what about follow-up care? Medication abortion is only 94% effective without evacuation surgery, according to a 2009 study published in the medical journal Obstetrics and Gynecology. The study followed 42,619 women, all the women in Finland undergoing induced abortion from the year 2000 to 2006 with a gestational duration of 9 weeks or less. The overall incidence of adverse events was 4 times higher in medical abortions compared with surgical. 1 in 5 women who have a medication abortion suffer adverse events. Over 15% hemorrhaged and 6.7% had an incomplete abortion, which means 1 in 20 women needed surgery to complete their abortion when their quote unquote self-managed abortion failed. Can we assume the woman who can't access the pills herself will have access to medical help if she needs follow-up care or surgical evacuation? If she hemorrhages and bleeds to death, why would DC not participate in the investigation surrounding her death? In what other medical field do we legislate protection for individuals who choose to distribute medication without authorization, no matter what happens to the woman? She hemorrhages, suffers an infection, an incomplete abortion, or a life-threatening ectopic pregnancy, which these self-managed abortion medications don't treat. Through this legislation, DC prioritizes legal protection for boyfriends, friends, parents, abusive partners, sex traffickers, nonprofit workers, over the health and welfare of women. We can do better to support women in their distress. As a woman, a mother of 2 daughters and 4 sons, and a resident of Ward 7, I urge you to reject B 240726 and B 240808. Thank you.
Thank you very much. Karen Mulhauser, welcome.
Yes, thank you very much, Congressman White and committee members for considering these 2 very important amendment acts and for the opportunity to share my views.
Are you able to turn your camera back on?
Whoops.
Wonderful.
Okay, sorry. I'm Karen Mulhauser, and I have lived in Washington since 1973. I'm testifying on behalf of myself, not on behalf of any organization, and in strong support for both of these amendment acts that enhance reproductive health protection for DC residents and for others. Making abortion illegal does not help women. Women suffer, and it doesn't stop abortions. It will just make them unsafe. These are issues that I've worked on most of my adult life. In the late 1960s, I taught middle and high school science classes where the teenagers had very limited information about sexuality and reproduction, and they came to me for advice. I was happy to give it to them. Then I volunteered full-time in Boston at Pregnancy Counseling Service in 69 and 70. This was a time when even contraception was illegal in Massachusetts unless you were married. I counseled up to 12 women and girls every day and helped them through the myriad decisions related to unplanned and unintended pregnancies. If they chose abortion and could afford it, we put them on chartered flights to London where abortion was legal. If they could not afford it, we referred them to Clergy Counseling Service, which was a network of ministers, priests, rabbis, who made referrals to illegal abortion providers who they had visited to make sure that their procedures would be safe. When abortion became legal in New York, we organized carpools. If people cannot decide when or if to have children, they cannot avail themselves of the economic and education opportunities that are available to those people who cannot become pregnant. It's just that simple. It's an equity issue. I worked for Planned Parenthood in Seattle, where I trained doctors and nurses and counselors in federally funded family planning programs in Washington, Oregon, Idaho, and Alaska. When we moved to DC in 1973, I was asked to open the Washington office of NARAL, the National Abortion Rights Action League, and then the next year they asked me to be the executive director. I've been on the board of Planned Parenthood Metropolitan Washington, and while I was board chair at PPMW is when we started offering abortion services at PPMW. It's clear to me why I have been so committed to protecting the freedom to decide whether or not to continue a pregnancy. After getting married, I lost my first wanted pregnancy 3 months early. And with my second wanted pregnancy, my son survived after being born 2 months early. Many women who have had pre-Roe v. Wade abortions are telling their personal stories, and I've decided to tell mine, which will help you understand my life commitment to these issues. In 1964, while a college student, I became pregnant because of a failed diaphragm. I self-induced a miscarriage. I had the most understanding parents who would have helped me, but I was ashamed and embarrassed. After believing I had survived without any incident, I fainted on the bus station floor on my way back to college. I woke up in the terminal office in a pool of blood, and the 4 or 5 staff who were there must have known what had happened. But when I got up and said I was fine, they let me change my clothes and get back on the bus. There was no offer of help, just please leave. I know how fortunate I was to have survived. And this clearly has influenced who I am these years later. I've never regretted the abortion because I wasn't ready to be a mother. Making abortion illegal definitely will not stop abortions. It will just make it unsafe. In conclusion, I thank you very much for consideration and strongly urge you to pass both of these amendment acts. Thank you very much.
Thank you. Judy Waxman, welcome.
There we go. Good afternoon, Chairman White and Councilwomen. I am Judy Waxman. I am a reproductive rights attorney, an adjunct professor at George Washington, and a member of the board of Planned Parenthood of Metro Washington. In the current debate on abortion, there's been very little attention to the centuries of history of women seeking out any possible way to limit their fertility, and therefore the crucial need to assure women that abortions can be safe and legal. Chinese records of abortion formulas date from 3000 BC. To induce an abortion, Greek and Egyptian women ingested a plant called silphium, which was so overused it became extinct. Indigenous women, shamans in what is now the United States, recommended abstinence except in the autumn, so babies would be born in the spring when food was plentiful. But if that didn't work, they recommended certain plants and herbs as an abortifacient. When Europeans came to America, they brought with them their own methods to limit fertility. Midwives, healers, and grandmothers passed on relevant information to each new generation. As the Republican appointed Justice Blackmun said in Roe v. Wade, at the time of the adoption of our Constitution and throughout the major part of the 19th century, a woman enjoyed a substantially broader right to terminate a pregnancy than she does in most states now, at least with respect to the early stages of pregnancy and very possibly without such limitation. Well, when did abortion become illegal? In the middle of the 1800s, the American Medical Association formed, and they advocated to end the practice of abortion in part because it was often unsafe, but also because midwives were the main providers of abortion. So if the practice were prohibited, midwives would be undermined to the benefit of doctors. State after state enacted laws to limit abortion, and by 1910, the process was basically illegal in the whole country. And yet women continued to have abortions. It was not safe, it was not legal, but they did it anyway. They continued to teach each other about plants and herbs and other substances that would induce abortion. They threw themselves down the stairs. They poked sharp items such as knitting needles and hangers into their uteruses. And by the 1960s, some women had learned how to do safe abortions, and even though it was illegal, they helped each other. Around then, 6 states and DC legalized abortion, but finally in 1973, The Supreme Court told America, that's enough. It's not any government's business to tell women how many children they should have. But last month, of course, our current Supreme Court said those justices were wrong. Government can meddle in women's decisions, and we know about half the states are going to do that. But of course, women are going to try to control their own bodies, regardless of what the Supreme Court said. The district is already a place where safe and legal abortions can be obtained. And as we've heard, women from all over the country are likely to come here for the services they need. I urge you to pass these bills so the district can be a sanctuary for women and other pregnant people wherever they come from, and also for the healthcare providers that want to help them. Thank you.
Thank you. Michael New. Welcome.
Thank you. Can you hear me?
Yes, I can.
Great. Thank you. I appreciate the opportunity to testify. My name is Michael New. I'm a professor at the Catholic University of America. I'm not representing CUA in any official capacity. I'm here as a concerned citizen, and I'm here to recommend opposition to both of these pieces of legislation. My main concern with both of these bills is I think it would make it a lot more difficult for police to investigate and prosecute people who use abortion to cover up other sex crimes. I think it could make it more difficult for police and to investigate and prosecute people who engage in statutory rape and use abortion to cover up their misconduct. It would make it more difficult for law enforcement to investigate and prosecute child predators. I think it would make it more difficult for law enforcement and to prosecute pimps and prostitutes. Another concern I have is that it may make it more difficult to prosecute people who unknowingly slip abortion pills into the drinks or meals of their partners, hoping to induce abortion against their partner's will. So these are concerns I have as I read the legislation. I also want to add that I think that abortion in the district is very unregulated. I think that the very least the district could do is provide accurate data on the number of abortions that take place every year. They don't do that. The most recent year for which the DC Department of Public Health has abortion data is 2015. That was 7 years ago. The data they do have is incomplete. According to the DC Department of Public Health, they say only 1,385 abortions took place. Schumacher, which does a survey of abortion facilities, said 3,800 abortions take place. So the DC Department of Public Health is giving us an undercount of about 63%. So again, I think if there's anything people could agree on, I think it's that we could have accurate data on abortions. I think it would give us better information about things like the efficacy of sex education programs. It was information about the efficacy of contraception programs. But this data we get is either timely nor accurate. We don't have that information. I also want to add that I'm a sidewalk counselor. I organize a group of people to pray outside the DC Planned Parenthood. We offer life-affirming alternatives to abortion-minded women. And again, we just see a lot out there. We see minor girls coming in for abortions unsupervised. We saw at one instance a woman escape the Planned Parenthood to get away from a partner who wanted her to have an abortion against her will. We saw ambulances show up at the DC Planned Parenthood on November 13th, 2021 and January 27, 2022. And I just wish the council's priorities here were a bit different. I'd really like it if you hosted a hearing at some point to find ways, creative ways, to help women with unintended pregnancies find mechanisms and find support to carry those pregnancies to term. I really don't think you should be spending your time trying to find ways to make abortion policy in the district even more permissive and endangering the health of women or I should say, endangering the health of both women and children. Thanks very much.
Thank you. Our next public witness, Heather Schumacher.
Thank you. Good afternoon, Chairperson White, committee members, and staff of the Committee on Government Operations and Facilities. My name is Heather Schumacher, and I'm the Director of State Abortion Access at the National Women's Law Center, which is dedicated to the advancement and protection of women's legal rights and opportunities. Thank you for the opportunity to speak in support of Enhancing Reproductive Health Protections Amendment Act of 2022 and the Human Rights Sanctuary Amendment Act of 2022. And also for your commitment and efforts towards ensuring abortion access in the district. The Law Center fights for gender justice in the courts and public policy and in our society, working across the issues that are central to the lives of women and girls, including childcare and early learning, education, reproductive rights and health, income security, and workplace justice. We also house the Time's Up Legal Defense Fund, which connects those who experience sexual harassment or assault in the workplace with legal assistance, and the Legal Network for Gender Equity, which connects individuals facing sex discrimination at work, at school, and in the healthcare system with legal help. At the Law Center, we know that access to reproductive health care, including abortion, is vital to gender justice. Access to abortion is a key part of a person's liberty, equality, and economic security. Everyone, no matter where they live or their financial means, should have access to abortion when they need it in their communities without stigma, shame, or barriers. But last month, the Supreme Court callously took away our constitutional right to abortion, a right that has been fundamental to our health, lives, futures, and society for nearly 50 years. We know the decision will have consequences that reach far beyond abortion access. The dangerous legal reasoning in the majority decision could signal a rollback of other fundamental rights, including the right to contraception, same-sex marriage, and consensual sexual relations. And the impacts are already being felt. In the days since the decision was released, multiple states have enacted total bans on abortion, while anti-abortion extremist lawmakers have proposed laws that criminalize those who provide abortions, those who seek them, and anyone who helps another person obtain one. Currently, people in at least 16 states do not have abortion access, either because their state has some version of a pre-viability abortion ban in effect, or because clinics are afraid to provide care due to legal uncertainty. In the coming months, nearly half of states are expected to ban abortion. Banning abortion will ultimately mean that some people won't be able to get access to abortion care and will be forced to carry their pregnancies to term. And there will be lifelong consequences for those people and their families. Denying a pregnant person an abortion creates economic hardship and insecurity, which lasts for years. This impacts will be felt most by women of color and those who have low incomes, people who already face challenges in accessing healthcare, and who may lack job security or paid leave. Beyond this nightmare of criminalization, clinic closures, and patients being denied care or having to travel thousands of miles, anti-abortion extremists are expanding their attacks. They're making it clear that they are threatening anyone and everyone who plays any role in abortion access, creating legal uncertainty and fear for loved ones, healthcare professionals, employers, universities and schools, businesses, city governments, among others. This decision has wreaked legal and public health chaos, even as the full extent of the harm is yet to be realized. Given this climate, it's absolutely critical that DC continues to protect and expand access to abortion and protect abortion providers and those who help people get abortions in DC from additional threats. The Enhancing Reproductive Health Protections Amendment Act of 2022 and the Human Rights Sanctuary Amendment Act of 2022 would do just that. I urge you to advance these bills. Thank you so much for your work on abortion access.
Thank you, Ms. Schumacher. And our I think final witness for this panel, Cleopatra McGovern.
Hello, good afternoon. Thank you for letting me speak. My name is Cleopatra McGovern. I was born and raised in Ward 1 in Washington, D.C. I currently live in Ward 1 and I currently practice in Ward 1 as a family physician. I'm also an abortion provider. I currently work in Virginia, but provide abortions in the DC area. I strongly support these bills. I think that DC is unique in its geographic and political location within this landscape. There's a lot of interstate travel to DC, even locally from Maryland and Virginia, and that practicing in the district does not protect providers from necessarily treating patients who are out of state. I think also with the advent and increase of telehealth, which is a wonderful new change in our medical system, this will be increasingly hard to regulate who we are seeing where they're living or where they're even currently residing, and that these bills would help ensure the safety of people seeking abortion as well as those providing abortion in the district. I also want to echo what many of my colleagues have spoken about in terms of self-managed abortion. self-managed abortion is very safe. And with the overturning of Roe v. Wade, I suspect that it will be an increasingly common option that people choose to terminate their abortions. I think that even in DC, as abortions remain legal, as this becomes a more common option, more district residents will choose to self-manage their abortion. This is because this method is safe, and it is often much less expensive than going through the healthcare system. The healthcare system can be incredibly alienating and then indeed even hostile and violent towards people seeking to terminate their pregnancies. And so I think that even if abortion remains legal in DC, this will be a growing area in which people will seek to have their abortion. I want to stress that the serious risks of a medication abortion, which is the most common form of abortion pursued by people self-managing their abortion, are very minimal. I think that a lot of the risks were overquoted. It's probably less than 2%, requiring some sort of follow-up for a life-threatening complication, such as a hemorrhage or an infection. And that the complications that will certainly occur in rare circumstances need to be treated by medical facilities, and that people should not fear going to medical facilities to seek out this care, and that the legal repercussions are what are going to keep people in unsafe positions while they self-manage their abortion. I think that legal abortion is safe. And I think that self-managed abortion is safe, and that with the passage of these laws, we can keep it legal. Thank you.
Thank you very much to this panel. Councilmember Henderson, do you have questions?
I do. Thank you, Councilmember White, and thank you to this panel of witnesses. Dr. McGovern, I think something you just said at the very end of your testimony is super important, in that and actually, I think listening to all of this conversation that has happened over the last few weeks after Dobbs, but this idea that should someone have a complication, should someone in other states, right? I think DC is fine now, but even in other states have some type of complication, the fear of going to a medical facility to seek care because you might be investigated as a result is just such a chilling effect that is going to have repercussions that I don't feel like people fully understand. And even before the Dobbs decision, there's a documentary on HBO Max, and I know Karen Mulhauser knows, Heather Booth and folks who were part of the Janes in Chicago. But like I was telling someone, I was like, Cook County Hospital in Chicago had an entire septic abortion ward, right? 40 beds. Everybody knew that was pre-Roe. That was what we were dealing with pre-Roe, and sort of coming back to that. On that, Ms. Mulhauser, thank you so much for your willingness to share your story in this forum or just anywhere in general. I know I think later coming up to testify is someone from We Testify that's talking about abortion stories and sort of normalizing people talking about it. And, I have a shirt that says, like, everyone loves someone who's had an abortion, because you don't know, like, there are so many, it's happened to so many people. So I wanted to say thank you for that. And thank you for your testimony. Dr. Parrott, I do have a question in terms of, this is kind of the weird part where you have like all of these states and jurisdictions. Is there any sort of, general guidance that physicians have been provided post the Dobbs decision about how to proceed here?
The answer is no. The short answer is no. And the reason, there are lots of reasons why. One, this legislation is intentionally designed, the reversal of Roe, sending it back to the states to cause confusion. That's the intent of many of the laws we've seen sweep this country, even prior to the complete overturn of Roe and Casey a few weeks ago by the Supreme Court. And so what we're seeing is doctors who aren't even sure about managing miscarriages and ectopic pregnancy. And so there is no directive. The other thing that's really worrisome is there is a desire to criminalize and punish people for providing care and for people for seeking care, of course. So the risk of criminalization is high. And so what we're seeing from the more than 500 doctors in our network is that people are frozen. They don't know what to do. And as a result, they aren't taking care of people. I went to school for 15 years training to be a doctor. The only thing I've ever wanted to do, and specifically with the intention of taking care of people in DC, because this is where I'm from. This is my home. And so to question whether or not I can practice medicine in the place that raised me, that made me who I am, is terrifying for me. And doctors around the country are really feeling the same thing. One other thing I want to add in response to that is I want us to be really careful. I'm so grateful for Ms. Mulhauser for sharing her story and for really talking about what we've seen prior to Roe. I want us to be very intentional about not conflating legality and safety in this moment in time. People have been safely managing their abortion for centuries, right? We absolutely cannot ignore what we saw pre-Roe. And with the advent of abortion pills now and the ability to access them outside of the formal medical system, the risk is not a medical one, it is a legal one. We already know of people who have been targeted, arrested, interrogated, criminalized for suspicion of self-managing their abortion, even prior to the Roe reversal. And the majority of those folks came into contact with law enforcement because they sought care, right? They went to the hospital, they went to their doctor's office, and they called the police on their patients. We need to be very clear with all of the providers in the city and in this country, really, there is no mandate to report anyone you suspect of self-managing their abortion. And in fact, it is a violation of our ethical principles and privacy laws in the field of medicine. So these mandatory reporting laws really are not are not applicable here in this moment in time. And our duty is to keep our patients safe, and reporting them to law enforcement does not do that. Criminalizing them does not do that.
Thank you, Dr. Parrott, I think you just gave the solid answer and response here. But I think it's also important to underscore, right? Like, we are not having a debate about medical safety. We are having a legal debate, which is like crazy when we're talking about health and reproductive care. Those are all the questions I have for this panel. Thank you. Thank you, Chairman White.
Thank you. Councilmember Nadeau, do you have questions for this panel?
Thank you, Chairman. I'm so grateful for everybody for their testimony, for the work they're doing on this issue.
Thank you so much. I appreciate that the conversation that was happening toward the end of Councilmember Henderson's round, as Ms. Mulhauser and Ms. Waxman pointed out in their testimonies. There's a long history of women trying to limit their fertility. And there's a long history of unsafe abortions, particularly prior to Roe. And we have to be very clear about that. On the issue of safety, and I'm glad you're still on, Dr. Parrott. One of the witnesses mentioned concerns about whether people from another state are qualified to assess whether an abortion is safe for someone in another state. How would you assess or respond to that?
The idea that we should oppose this legislation because of concerns about safety is an outright lie, like many of the statistics that were put forth. Dr. McGovern was generous in describing it as an exaggeration. She's kinder than I. It's absolutely untrue. And so these laws, the opposition to this legislation is not being put forward because of a desire to keep our communities safe, but a desire to eliminate access to abortion, period, and to punish those that are seeking care. We need to be very clear about what this opposition is about. So talking about risks of complications, about whether or not folks can care for people outside of their communities, if nothing else, if we learn not one single thing from the COVID-19 pandemic, we learned that managing care remotely and the use of telehealth is safe. The barriers that are put in place for accessing abortion care in general and medication abortion specifically are not because of medical issues, but because of ideology. Mifepristone, the medication we use for medication abortion, is restricted. It is one of the safest medications. It is safer than medications you can buy over the counter at CVS. It is not restricted because of safety. We care for patients outside of our communities all the time via telehealth. We've seen that through the COVID-19 pandemic. Abortion should not be exceptionalized in this way, and that is what's happening. That's how we know that it has nothing to do with health and well-being. It has nothing to do with the safety of our communities, everything to do with power and control.
I appreciate that response. Something that came up, I think, more clearly in responses than in testimonies is the issue of criminalization. And so there will be an imbalance in criminalization of women versus men. And we have to think very seriously about what that results in and whether that's something that we're intending to do in our country. I do want to thank the witnesses for this panel. Continues to be a robust and diverse discussion on an incredibly important issue. So I want to thank you all for being part of this discussion. We're going to move to our next panel. That would be Israel Cook, Kelsey Kerr, Allison Tombros Corman, Karishma Oza, Vittorio Levy, Abigail Rosenthal, Michaela Deming, Grayson Quay. And Sally Greenberg, if you are here, please turn your camera on. Israel Cook, welcome. You can begin when you're ready.
Yes, thank you. Thank you, council members, for having me today. My name is Israel Cook. I use she, her pronouns, and I'm the State Legislative Fellow at the Center for Reproductive Rights. The Center for Reproductive Rights is a legal advocacy organization dedicated to protecting the rights of individuals to access safe and legal abortion and other reproductive health care. The Center strongly supports Bills 24808 and 24726. The Supreme Court of the United States made the devastating decision to overturn Roe v. Wade's central holding that the decision to continue or terminate a pregnancy rests with the individual, not the government. This overruling of Roe has left us with a patchwork of laws across the country that has increased the difficulty for individuals to access legal abortion care. While DC protects the right to abortion, this does not stop states hostile to abortion rights from trying to keep individuals from accessing abortion care in DC and preventing abortion providers from delivering essential healthcare services. Now more than ever, DC must redouble their efforts to expand laws to bolster the right to choose to terminate a pregnancy. The Human Rights Sanctuary Amendment Act of 2022, or DC Bill 24808, prohibits DC governmental agencies, courts, and law enforcement from cooperating with out-of-state investigations and legal actions arising from the lawful provision of abortion in DC. This bill protects providers and individuals from civil litigation arising out of laws passed in states like Texas, Oklahoma, and Idaho that allow private citizens to sue individuals that provide or assist in the provision of abortion. Restrictive laws such as these have a chilling effect on providers by endangering their professional licenses, creating monetary or criminal penalties for providing care, or potentially causing the loss of their practice. Without explicit legal protections, abortion providers in DC risk penalties when providing care to non-residents. Many out-of-state residents frequent the district for personal and professional reasons. Without protections, providers could face serious civil and criminal risks if they provide care to these out-of-state patients. Protections like B-24-808 can mitigate the harm from states hostile to abortion care and protect individuals and reproductive health care providers providing or assisting in the provision of abortion care. The Enhancing Reproductive Health Protections Amendment Act of 2022, or DC Bill 24726, will provide protections against criminal and civil penalties for individuals who self-manage abortions and others who assist them. With the rise of telemedicine and medication abortion during the COVID-19 pandemic and the rise of self-managed abortions in the states with dwindling access to abortion care, protections for individuals seeking and assisting in self-managed abortions are vital. As we continue to see an increase in self-managed care, states hostile to abortion will continue to criminally and civilly target individuals assisting, providing, or participating in such care. These penalties will fall hardest on Black, Indigenous, and people of color, poor folks, and other most impacted communities. As patients are forced to travel out of state to access abortion care, DC will become an access point for those seeking abortions and other reproductive health care services. Legal protections like those and these two bills are essential to maintain abortion care by protecting reproductive health care providers providing legal care in DC from overreaching laws in other states that restrict abortion access. Just as California, New York, Connecticut, Delaware, and New Jersey have, it is critical that DC enact legislation to protect individuals' bodily autonomy and ability to receive vital healthcare services. Abortion is healthcare that must be accessible to all. For these reasons, the Center for Reproductive Rights strongly supports B-24-808 and B-24-726. Thank you for the opportunity to provide testimony.
Thank you very much. Kelsey Kerr.
Good afternoon, DC Council members, and thank you so much for taking the time to hear from us today. My name is Kelsey Kerr. I am a student at the George Washington University Law School and the Reproductive Health Coordinator of my school's If When How chapter, who has also volunteered and spoken on behalf of Resolve, the National Infertility Association. Thank you for allowing me to speak to you all in support of the Enhancing Reproductive Health Protections Amendment Act of 2022 and in support of the Human Rights Sanctuary Amendment Act of 2022. Abortion is a right that is not a luxury for many women, and for myself, it could become a matter of life and death. I have Turner syndrome, where an arm of one of my X chromosomes is shortened. Because of the risks of miscarriage posed by Turner's, my husband and I knew that we would need to see a specialist as we began our family building process. We did all of our initial appointments from home because of the risk of COVID, and I will never forget sitting in front of our computer at our dining room table, frozen, as I learned that I would be high risk for an aortic dissection were I to carry our embryo. So much so that the fertility center doctor we spoke with told us that they would not allow me to do so because of the risk of death. Since the Dobbs ruling, it still hasn't hit me that if I lived in a place without access to abortion, if I wasn't privileged with the ability to travel elsewhere to obtain one, I could die. When I told this to a friend, she said she was glad it hadn't hit me yet. That would mean the fight was over. This is why it is important that we take up both the Enhancing Reproductive Health Protections Amendment Act of 2022 and the Human Rights Sanctuary Amendment Act of 2022. Persons who need access to abortion need no more reason to demand it than control over their own bodies. But in dire situations like mine, particularly considering that the law in Virginia where I live is uncertain as Governor Youngkin advocates for a 15-week ban, it truly could become a matter of life and death. Without a doubt, Governor Youngkin will continue to push the line back further. In certain states like Texas, it has already become a matter of prosecution, which the Human Rights Sanctuary Amendment Act aims to prevent while protecting contraception in general. The Enhancing Reproductive Health Protections Amendment Act is vital in the same vein. It provides greater access to medications for self-managed abortion, medication that paves the path for so many people to continue their lives as they see fit by enabling medical professionals to do their jobs. All of this and more is what the court has found. Just 1 week before the Dobbs ruling came down, I had to call the fertility center again to make sure the 2 embryos my husband and I were able to create were not in Virginia. If they were, knowing what was about to come, I would have had to have paid to have them moved. We are moving backwards, and not only are we facing the threats we see now, but those mentioned in Justice Thomas's concurrence and more. We are seeing the threat to contraception, the right to be together as an LGBTQ plus couple, the right to gender affirming care, and soon we may see threats to IVF and surrogacy, to name only a few. The legislation you are considering today will not only help people like myself, but will help anyone who needs access to abortion to feel more secure in their own skin, and it will enable progress in the family building process by modeling the fundamental right of choice. I urge you to advance these bills. Thank you.
Thank you very much. Next public witness is Allison Corman. Welcome.
Thank you. Good afternoon, DC Council members. My name is Allison Corman, and I'm joining you today on behalf of the DC Abortion Fund. Thank you for allowing me to speak to you all in support of B24-0726, the Enhancing Reproductive Health Protections Amendment Act of 2022, and B24-0808, the Human Rights Sanctuary Amendment Act of 2022. The DC Abortion Fund is a 501c3 nonprofit that makes grants to pregnant people in the DC area, as well as those traveling to the area who cannot afford the full cost of an abortion. DCAF is the only organization in the DC region that focuses solely on providing this service in our community. The DC Abortion Fund's vision is to make reproductive choice a reality. We exist to do just that by providing financial support for individuals of any age who lack resources to abortion care. Folks who ask for our support come to us from DC as well as from other states where they face a multitude of state and national restrictions designed to deny access to abortion care. These restrictions are designed to further oppress Black, Brown, and Indigenous people, along with poor folks, trans folks, and undocumented people. Now that the Supreme Court has overturned our right to abortions, as states across the nation criminalize abortion, we are already seeing callers struggling to navigate a complicated and confusing legal landscape to get the abortion access they seek and deserve. Given this climate, it is absolutely critical that DC continues to protect and expand access to abortion. The Enhancing Reproductive Health Protections Amendments Act of 2022 would expand existing protections to those that support and assist individuals self-managing their abortion, and to shield those who provide, dispense, or transfer any product used for self-managed abortion from penalties. In a climate where pregnancy outcomes will be increasingly scrutinized and punished, this protection is timely and necessary. As an organization that supports people who seek abortions, this type of protection is critical. The overturning of Roe v. Wade has not just impacted states where abortion is now or will soon be illegal. It has impacted abortion access across the country, continuing to target the most marginalized and oppressed. The wait times for abortions in clinics are already increasing, and people need every available option for abortion, including and especially self-managed abortion. Black, Brown, and Indigenous people, people with low incomes, LGBTQIA folks, and other marginalized communities will bear the brunt of these impacts, just as they would bear the brunt of the criminalization of self-managed abortion if laws are not created to support and protect them. The Human Rights Sanctuary Amendment Act of 2022 would prevent DC from cooperating with out-of-state investigations that seek to impose civil or criminal liability for abortion care, the use of contraception, and other protected conduct. As an abortion fund, one of the many types of organizations that could be impacted by Texas SB 8-like laws, these types of protections are important to us. The number of states in which pregnant people can seek abortion services is shrinking. We must do everything we can to protect reproductive freedom, justice, equity, and access in the states and in this district where the laws state that abortion is and will remain legal. These are exciting steps towards enhancing and protecting abortion access in DC. We look forward to working with you to continue to ensure pregnant people have access to abortion and that pregnant people, abortion providers, and other folks like abortion funds that support pregnant people are not penalized. I urge you to advance these bills. Thank you.
Thank you very much. Karishma Oza, welcome.
Good afternoon, DC Council members. My name is Karishma Oza. I use she, her pronouns, and I live in Ward 6. I'm the Director of Patient Services at DuPont Clinic here in DC. And hi to everyone watching at Clinic right now. I hold a master's in public health in maternal and child health from the UNC Chapel Hill Maternal and Child Health Department. I am a trained abortion and postpartum doula, an auntie to 9, and a descendant of South Asian immigrants. I love abortion and I love people who've had abortions. Thank you for allowing me to speak to you all today in support of bills 240726 and 240808. Based in DC, DuPont Clinic is one of only 3 independent abortion clinics in the US that provides abortion care in all trimesters. 2/3 of the folks that we serve travel from outside the DMV area. This is due to abortion bans, gestational age limits, and complex medical conditions that create barriers to accessing care locally. Our model centers individuals receiving abortions. It's grounded in best practice, and it affirms people of all genders. As a reproductive health organization, DuPont Clinic understands that the right to accessing abortion care is deeply connected to the human right to maintaining personal bodily autonomy, the right to have children, the right to parent the children we do have in safe and sustainable communities. We never ask patients why they are seeking an abortion because their reason, whatever it may be, does not affect whether or how we care for them. I want to center the voices of 2 people we served at our clinic for abortion care. The first person said, "As soon as I walked in, I was greeted with warm smiles, kindness, and calm. I didn't feel judged or pressured. I got emotional and they were so patient with me, letting me know that it was completely okay and normal to feel what I was feeling. They make the hardest thing I've ever had to go through that much easier." The second person said, "I came from across the country to have a procedure done that no one else would do. I was very scared to come from so far away, so desperate for help. This clinic gave me my life back and saved my family from a lifetime of heartache." So we all know that statewide abortion bans like Texas's SB 8 have prevented or delayed people's ability to access care for a while now. As a result, people across the country find themselves in need of abortion care in all trimesters. On the day of the Supreme Court decision, our call volume at DuPont Clinic went up by 66%, and I know others in DC probably experienced the same. Since January, the average gestational age, or the number of weeks into pregnancy at our clinic, has steadily increased every month. In January, it was 27.2 weeks into pregnancy. As of today, the gestational age average for July is 29.1 weeks. That means with fewer clinics open, people are facing massive delays in care. And now that the Supreme Court has overturned our right to abortion, it's essential that DC continues to protect and expand abortion for all people, to keep abortion providers safe, and to protect abortion funds and practical support organizations helping people receive care in DC. I want to highlight 2 practical support organizations, the Midwest Access Coalition and the Bridget Alliance, who wanted to share their support of our clinic and of these bills. Diana Parker Kafka says, from the Midwest Access Coalition says, DuPont Clinic sees people who are conquering domestic violence situations to get care later in pregnancy. Young people who know they aren't ready to parent, people with no local access to care, and people who have been forced to carry a pregnancy longer than they want to or longer than it's healthy for them. DuPont returns autonomy into the hands of the people. Marielle Neris Rodriguez of Bridget Alliance says, one of the many DuPont clients we supported from the South was escaping an abusive relationship and was struggling to keep her family afloat. Bridget Alliance provided flights, a hotel stay, and meal support. Afterward, that client said, "I can't even imagine how I would have done this without you. I wish I could give back somehow to those in the same position I was in. As a DC resident, a person with capacity for pregnancy, a person who loves and supports abortion care every day, I urge you to advance these bills, and I welcome any questions. I also welcome any council members to come visit our beautiful clinic in DC. Thank you so much.
Thank you very much. Our next public witness is Vittorio Levi.
Yes, Councilmember White, thank you. My name is Vittorio Lino Levy. I am a resident of Ward 1. While I was born in Miami, I love this beautiful city and I'm pursuing my career here. My experience growing up in Miami is one of several reasons I'm here to testify today before the council. Far too often, discussions regarding the right to pregnancy decisions prominently feature men exhibiting their opinion and control in ways that grant little compassion or understanding for the personal healthcare choices of women. I hope to share a personal experience that shaped my support for a woman's right to make decisions that are best for their overall health and future. I have COVID right now, so a little. There are countless verified studies that provide statistical information on the negative effects of denying women abortion care. They are exponentially at higher odds of being unemployed and falling into or remaining in poverty. The drastic change from opportunity to maternity also creates complex obstacles in elevating them themselves from poverty. Miami having the third highest income and wealth inequality in the US after only New York and San Francisco, the latter with the dystopian juxtaposition of the wealthiest companies in the world's headquarters across the street from unhoused people, people trapped at the bottom rung of a ladder they cannot climb without the proper paperwork, which they can't get without proof of housing, which they can't get without the proper paperwork. This may seem like a digression, but we are all connected and our problems are connected too. Many women who face unwanted pregnancies have no knowledge of where to go, what to do, and consequently, no knowledge of their options to consider because of the established socioeconomic and political stigma surrounding abortions. I attended Florida International University in Miami for my bachelor's studies. Without my help to access an abortion, a classmate and friend would not have been able to pursue her dreams to continue her education and make the impact in the world that she's making today, more than a decade later. She would have carried an unwanted pregnancy, conceived in a relationship with a man who had already transferred to another university out of state to term. I don't know what her life would look like other than that it would no longer have been hers to decide. My helping her was as much about that man, my old roommate, as it was helping my friend. When you live with someone, you come to learn their strengths and weaknesses as an adult and a human. It becomes apparent, self-evident, whether they will be the best parent they could be. At 19 years old, he was not prepared for fatherhood at 20. They both knew this. I know that neither of them was prepared to raise a child or start a family. I say neither of them because it takes two people to make a pregnancy. Their dreams for college and a better life vanish, replaced with notions of working full-time to support their newborn. Freedom does not mean being able to avoid choices, but make them for yourself, even if they are difficult. That decision, her choice, allowed them both the opportunity to continue their education and seek other life opportunities that would not have been possible without the abortion that recentered her as the master of her own destiny. I share this intimate story because the recent changes in the Supreme Court and the attempts by states to legally restrict abortion will have dangerous results for the lives of women throughout the United States. Of course, the results of this story are far less tragic than some of the experiences I have witnessed during my years working in Austin, Los Angeles, back in Miami, and now here. But as the justice system eliminates a woman's right for access to alternative options for pregnancy, these decisions will have devastating and lasting effects on the lives of women, loved ones, and the greater community. These bills seek to further facilitate an affirmative right to healthcare options, including the termination of a pregnancy, so women have the basic human right to make the best decisions for their lives, their health, and their future. Thank you.
Thank you very much. I hope you feel better. And Mr. Levy, I apologize for mispronouncing your name. Our next witness is Abigail Rosenthal. Welcome.
Can you hear me? All right.
Yes.
Okay, perfect. Good afternoon, council members and those gathered today. My name is Abigail Rosenthal. I'm the internal president of Washington College of Law's If One How chapter and a legal intern at IPAS Partners for Reproductive Justice, but I am testifying here today in favor of these bills as a private citizen and a resident of DC. The recent efforts to criminalize abortion and other reproductive health care are unconscionable. It's heartbreaking that we even need to be here today to defend individuals from being prosecuted, fined, threatened with state violence, or otherwise made to feel unsafe for seeking fundamental health care and for making the basic decisions about their own bodies free from state violence. Even in volunteer groups I'm part of in DC, in our own safe state, the chilling effect of other state laws is palpable. Those offering their homes, their moral support, and their compassion to out-of-state patients are beginning to fear the potential for criminal liability, and it's essential that we take a stand to protect them. There's no choice as deeply personal as whether or not to become a parent. Parenthood is something that should be celebrated and chosen freely, not forced on individuals under the threat of state violence. This is doubly true in a country that has astronomical rates of maternal mortality, particularly for women of color, and a country where there is no federal right to paid maternity leave or basic health care. The science has shown us that self-managed medication abortion is a safe and effective procedure. Self-managed abortions have been practiced for centuries through a variety of methods, both safe and unsafe. As a child, I was told about my great-grandma Rebecca, who was forced to resort to throwing herself down a flight of stairs in order to end an unwanted pregnancy. She already had 6 children at home that she was scraping by to support. Luckily for her, she survived, but thousands of people around the world are not that lucky and have not been that lucky throughout history. I often think about how desperate and isolated she must have felt in that moment, and how there were so few options available to her. I don't want anyone to have to feel that same depression, isolation, and lack of options when they're just trying to make the best decisions for themselves, their health, and their families. I can only imagine how much worse that experience would have been, how much more traumatizing if it had been surmounted with arrests and imprisonments. We're so lucky today to be able to have medication abortion, a procedure that's been proven again and again to be safe and effective, many times safer than childbirth. And it's essential that we provide legal protections for self-managed abortion so that no one is forced to resort to unsafe methods. Moreover, we must clearly say that our people's lives are not disposable, that no one should die, should be made to feel scared, or should be prosecuted or imprisoned in an attempt to exercise their basic rights and to access health care. I urge you to advance these bills. Thank you so much for your time.
Thank you very much. Next public witness is Michaela Deming.
Good afternoon, Council and Chair White. My name is Michaela Deming. I'm the Policy Director of the DC Coalition Against Domestic Violence. DCCADV is the federally recognized statewide coalition of domestic violence service providers in the district and includes domestic violence specific housing providers, counseling and case management services, legal services, and culturally specific organizations. We serve intimate partner and sexual violence survivors through all of our member programs. Intimate partner and sexual violence continue to be a significant public health concern for DC residents of all ages. I am here today to inform the Council about the intersections of domestic violence and reproductive choice. You've heard some of these statistics already, but bear with me. 1 in 4 women will experience domestic violence in her lifetime, which leads to disastrous effects for the victims, their families, and their communities. We also know that 39% of women living in DC have experienced sexual violence, physical violence, stalking, or a combination thereof perpetrated by an intimate partner, and that 50% of women in the district have experienced psychological aggression by an intimate partner. Reproductive coercion, which can include sabotaging birth control, forcing pregnancy, or even forcing an abortion, is a tactic used by many abusers. 40% of pregnant women who have been exposed to abuse report that their pregnancy was unintended. That is compared to just 8% of non-abused women. Young women and girls between the ages of 16 to 24 are at the greatest risk for experiencing dating violence and relationship abuse. Nationally, more than half of women and men who have been physically or sexually abused or stalked by a dating partner first experienced that abuse between the ages of 11 and 24. Dating violence can negatively affect health outcomes throughout one's lifetime. For youth in DC, experiencing dating and sexual violence has been associated with a significantly increased likelihood of mental health symptoms, including suicidal ideation and suicide attempts. Pregnancy coercion and birth control sabotage are also common among young women utilizing family planning clinics. In the context of partner violence, they're associated with increased risk for unintended pregnancy. Teen girls who have been physically or sexually abused are 6 times more likely to become pregnant. Expanding the age range to girls and young women between the ages of 16 to 29 in family planning clinics, again, 53% have reported physical or sexual violence from an intimate partner. Approximately 1 in 5 girls and young women said they experienced pregnancy coercion, and 1 in 7 said they experienced birth control sabotage. Pregnancy, childbirth, and postpartum are already times of heightened risk for mortality for pregnant people, especially pregnant persons of color. When the pregnant person is in a violent relationship, the risk to them during this time increases significantly. According to the Journal of Obstetrics and Gynecology, homicide during pregnancy or within 42 days of the end of a pregnancy exceed all the leading causes of maternal mortality by more than 2-fold. Pregnancy was associated also with a significantly elevated homicide risk in the Black population and among girls and younger women aged 10 to 24 years across racial and ethnic subgroups. Homicide is the second leading cause of traumatic death for pregnant and recently pregnant women in the US, accounting for 31% of maternal injury deaths. In addition to the risk of homicide, women experiencing abuse in the year prior to and or during a recent pregnancy are 40 to 60% more likely than non-abused women to report serious complications during their pregnancy, and are 37% more likely to deliver preterm, which is also a risk factor in infant mortality. Trying to skip to the end here. We are specifically looking, however, for some language in the bills that could potentially prevent an abuser, that could prevent the abuser from being penalized, is what the language currently says. And we would like an amendment to the bills that would clarify that there could be some sort of an action taken if an abuser is taking an action to force someone to have an abortion, as opposed to that person making a decision through their voluntary consent. And the rest of that is in our written testimony that has been submitted. I thank you, Chairperson White, for the additional time and for letting us testify today.
Thank you very much, and I appreciate the point at the end. And we'll look closely at your written testimony. Our final public witness for this panel was Grayson Quay. Welcome.
Yes, thank you for the opportunity to testify, Councilmember White. I'm a former DC resident. I also work as a pro-life sidewalk counselor in the district. Before I get into my 3 brief points, I wanted to correct the record on a few things. Councilwoman Lewis George said something about women should have the power to choose when they become a parent. That's incorrect. When you are pregnant, you are already a parent, and it is your duty and the duty of the community around you to preserve the life of that child from conception through natural death. She also said that she couldn't believe we were having this conversation in 2022 and that we can't go backward. I don't see what the relevance of the year is. It's as if I were to say that something is wrong because someone thought of it on a Wednesday. And going backward is the correct direction to go if you've been going in the wrong direction, which is the direction we've been going in, the wrong direction. And then also Councilwoman Henderson mentioned the city's most vulnerable residents. The city's most vulnerable residents are actually the unborn. They're the only group within the city that can be killed with impunity and with no legal consequences. So I wanted to begin by saying that this bill, at best, in its most charitable interpretation, seems like an unnecessary bit of virtue signaling. The Dobbs decision came down, so you need to do something to reaffirm that you're pro-abortion. But all this stuff about criminalizing contraception use and same-sex relationships, it seems absurd to me to think that Maryland is, for some reason, or Virginia are on the cusp of criminalizing same-sex relationships, and that it's urgent that the district take some action to prevent this. Second, I would just point out that Washington, D.C. is already vastly out of step with the rest of the country and with public opinion, even as the law existed under Roe v. Wade. Abortion is way too deregulated in this district as it is, to the point that you don't even know how many abortions are being performed in the district. The numbers I have in front of me, the Guttmacher Institute reported 3,800 abortions in DC in 2015. DC only reported 1,300. That's off by 63%, which is insanely egregious when we're talking about something as important as ending an unborn life. Also, abortionists in this city literally get away with murder. Cesare Santangelo may well have murdered several born alive infants, and the city government refuses to investigate this. There's also a woman operating a clinic on Georgia Avenue who is a nurse practitioner, not even a doctor, who provides abortions up through 9 months, who botched an abortion and drove the woman who was the victim of this across state lines with her entrails hanging out of her, and then lied to the hospital, and is facing a multi-million-dollar lawsuit as a result. And yet you're coming today and saying that we need fewer regulations on this procedure. And then finally, abortion doesn't solve social problems, it papers over them. The last speaker spoke quite a bit about sexual and domestic violence. I have personally witnessed multiple times women being dragged into clinics by their abusive boyfriends, and the clinic escorts simply smile and hold the door for them. And I'm sure they don't face any more scrutiny on the inside as well. If we really wanted to serve people in the district, we'd make sure that we could provide for them and for their families from conception through natural death. We'd focus on poverty and food security and housing, but instead we're focusing on killing more of them in the womb, which I think is a true dereliction of duty and just an absolute moral tragedy. And I'll say that it's been viscerally disgusting to me to listen to some of this testimony. Thank you.
Thank you very much to this entire panel. Councilmember Henderson, do you have questions for this panel?
I want to thank the witnesses who testified, and Mr. Levy, I want to say, I think is how your last name is pronounced. I hope you are recovering well from COVID. And I appreciate you testifying even through those symptoms that you are experiencing. Is Ms. Corman still on from the DC Abortion Fund? Okay, great, thank you. Ms. Corman, I was, I think that, or at least in terms of the impetus around the legislation that I introduced, again, I was watching what was happening in other states, laws that were being introduced. My bill came way before the Dobbs decision. And one of the things that kind of caught my eye was this attempt to say, oh, if what was happening in Texas around the bounty law, some other states trying to sort of pick up on that. Are you all seeing any hesitation from individuals who are wanting to volunteer or donate as a result of feeling like, oh, I could be criminalized perhaps in Texas or something to that effect? I'm just curious in terms of like the reverberating effect or chilling effect, really, that those laws are having.
Yeah, thank you for your question. I'm really pleased to say that you asked about both funding and getting engaged with the organization. I'm pleased to say that we've seen the entire community rally around the DC Abortion Fund and the folks that we are here to support. So not from that perspective, but we are absolutely having to think incredibly carefully about navigating this new landscape and making sure that we are supporting every single person we can, and at the same time working within the confines of the law to provide support for legal abortions. And it is a very, very tricky landscape to be navigating. And I think it is fair to say that we are seeing some folks who are very aware of those circumstances and being thoughtful about how, you know, their engagement could be used against them, for lack of a better way to say that.
I mean, I think that's again, like I said to the previous panel, that is the weird part of this, right? We are not having a medical conversation. We are having a legal discussion as part of this. And, you know, in that, you know, we're having this in our committee, but also having to have the Attorney General testify, as opposed to say, you know, Dr. Nesbitt from the, you know, head of our public health agency here. Thank you for that. Ms. Kerr, I think I'm saying it right, Kelsey Kerr, I wanted to say thank you so much to you for also sharing your story as well. I feel like in this particular time we're in, a lot of people are having, or not having to be, but are being called upon to be incredibly vulnerable in public, to share their stories. And I feel like in some instances, we've gotten this far in this debate because maybe some people feel like, oh, it's just a small minority of people, or it is or the narratives that are being built up around who are the type of individuals who need to seek this type of care, and where they are and all of these different pieces. And I feel like the more that we're open with it, but that only requires people to be like yourself and other witnesses to be vulnerable and sharing their story. And so I wanted to say thank you to that. I don't have any other further questions for this panel, but Councilmember White, I would be remiss if I say this. As a person who's been pregnant 3 times, I have 2 children. It is incredibly offensive to be lectured to by someone who has never been pregnant in terms of the decision of whether or not to carry a pregnancy to term. And so I just want to keep that in mind. And for other residents or witnesses who may be listening in who feel like some of this conversation is very tough for you, it is okay to take a break from it. But I also want you to know that you have elected representatives who are going to defend your right and your voice. And so if you feel like you can't listen in any further, that is okay. We are here, but I'm just going to say, like, if you've never been pregnant before, that's not to say that you can't be part of this conversation, but I'm just going to leave it there. Thank you, Councilmember White.
Thank you, Councilmember Henderson. Councilmember Nadeau.
Thank you, Chairman. I did have a question for Michaela Deming. Thank you. Great. Thank you for your testimony and for engaging with my office on this. I just want to say that I support your proposed revisions and that my office has shared draft language incorporating them into the bill with the committee. To be clear, I just want to make sure, do your proposed revisions fully address your concerns regarding potential coercion in making reproductive health decisions?
Yes, we believe that adding in the terms around voluntary consent of the person who is pregnant being the one who's making the decision, that would address that concern that somebody who is using abuse or reproductive coercion, that would be addressed. And we appreciate working with your office on that.
Great. Glad to work with you. Thank you for raising this really important concern. Thank you, Chairman. Thanks to all our witnesses.
Thank you very much. One quick question for Karishma Oza. One of the things you mentioned in your testimony was the issue of delays in care, particularly post-Dobbs. What impact is that having? What risk does that raise?
Thank you for the question. Yeah, certainly folks who are calling our clinic to receive essential medical care. And Allison from DCAF highlighted this as well, that folks are seeing delays of 2, 3, 4 weeks in order to get care at our clinic and at clinics in DC. As more clinics across the country are being forced to shut down, that just limits options for folks for where they can seek care. And so what that looks like in terms of risk or concern, I mean, the risk of continuing a pregnancy that's not safe for someone to carry, being pregnant for longer than someone wants to be or needs to be, delays. And as people get further into pregnancy, abortion procedures increase in price. People having to take more time off of work, find childcare, raise funds to be able to pay for travel, for procedures. The more that folks have to delay their access to care at our clinic and at clinics across DC, the more harmful impacts are on their lives, on their communities, on their well-being, on their safety. So we would really urge for the council to support, enhance, protect, open up more, support the opening of more clinics in DC so that we can start to see folks in areas where abortion is restricted or banned.
Appreciate it. Thank you for that. I'll just correct one thing for the record. I don't never mind people testifying who have different views than I do, but with respect to the issue of people being killed with impunity, I just want to correct that record. Black people are killed with impunity across this country all the time, and I don't want to have a conversation about killings with impunity and not clarify that issue. But I do want to thank all of our witnesses for being part of this conversation. We're going to move to our next panel of public witnesses, which will include Carlotta Arias, Dana DeMattia, Larry Sirignano, Victoria Anderson, Johanna Faith, Maddie Feldman, Robin Tucker, Ellie Levenskew, Jean Thoreau, Bria Johnson, Fardat Falarin Ahmadi, Martha Salt.
Good afternoon. Good afternoon, members of the council. My name is Carlotta Arias. I am a mother of twins, a person who had an abortion 18 years ago, and the policy and U.S. partnership advisor at IPAS for Partners for Reproductive Justice. We are a global reproductive justice organization working over 18 countries to protect access to abortion and contraception. Thank you all for allowing me to speak to you all in support of the Enhancing Reproductive Health Protections Amendment Act of 2022 and the Human Rights Sanctuary Amendment Act of 2022. I'm here to speak in favor of these bills because bold action on these issues cannot wait. As a global organization, we know firsthand what happens when necessary healthcare is denied and criminalized. People die, health declines, poor women are incarcerated at higher rates. There is a higher risk of deportation for the undocumented community after seeking abortion services. At the end of the day, our communities suffer. No one should be criminalized for seeking healthcare, for making the best choice for themselves, for their health and for their families, and no one should be criminalized for providing healthcare. Moreover, we know that criminalization does not eliminate abortion. People have been terminating their pregnancies for generations across cultures, faith, and societies. Criminalizing abortion merely drives the procedure out of the medical system and out of social safety nets to less safe and regulated environment, and makes what is a common experience an extremely isolated one. The burden of these measures will not be felt equally. They will be disproportionately borne by those who are the most vulnerable in our society, those who are not white, who are low income, those who are already struggle to receive adequate health care. We also know that from our work that self-managed abortion is a safe and an effective procedure, far safer than childbirth, and often the only method that many people have access to. As vulnerable people around the country look for guidance, DC is uniquely positioned to model how we might protect and uplift our citizens and those from other states. We must push back against these assaults and demonstrate that our legislators value the health and lives needed to protect and support their constituents. Thank you very much for the time.
Thank you very much. The next public witness is Dana DiMatteo. You have to accept attendance. Dana, do you see an option to accept attendance? After you do that, you'll have to turn your camera on. While we work through that, we will move to Larry Sirignano. Are you with us? Victoria Anderson.
Hello, good afternoon. My name is Victoria Anderson, and I'm here to testify on behalf of American Atheists. And thank you for allowing me to speak about American Atheists' support of Bill 24-0808, the Human Rights Sanctuary Amendment Act of 2022. American Atheists is a national organization that focuses on the civil rights of non-religious people and the separation of church and state. Atheists and non-religious people overwhelmingly support abortion access, with 88% believing that abortion should be legal in all or most cases. When lawmakers propose bills that attack abortion providers, impose burdens on people seeking abortions, or restrict the medical procedure itself, they are undermining the secular values that our country was founded on. These bills interfere with people's rights to live in accordance with their religious or non-religious beliefs, and to be free from having others' religious beliefs imposed upon them. Across the country, bills have been passed which threaten people's ability to access abortion. Marginalized populations are affected the most by these measures and face the most barriers to care. For example, when necessary reproductive health care isn't available, there's a 33% increase in pregnancy-related deaths for Black mothers. These numbers will only get worse as more politicians seek to impose their religious agenda upon others. Even in places where there are not restrictive abortion laws, people often cannot access this critical health care. For example, I was born and raised in Nebraska, and like many rural Nebraskans, my family only had access to faith-based medical providers. These institutions often operate under directives that prevent doctors from providing the best evidence-based medical care for these patients. Instead, those patients must travel sometimes hundreds of miles to access the health care they need. Washington, D.C. is one such place that people travel when they can't get help at home. As others have discussed, 68% of abortions performed in D.C. during 2019 were for non-residents. With the overturning of Roe v. Wade, it will become more difficult for millions of people to access abortions if they need it. Because of this, it's more important than ever to enact legislation that will protect and expand abortion access for both district residents and those traveling to the district for care. People are capable of making decisions about how and when to have families if they want them, and they are capable of making decisions about their reproductive health care. Lawmakers should absolutely not be interfering with these critical and personal decisions. I urge you to advance this bill, and thank you very much for your time.
Thank you. Johanna Faith.
Can you hear me all right?
Yes.
Awesome. Good afternoon, members. My name is Johanna Faith, and I am the Capital Area Regional Coordinator with Students for Life of America and Students for Life Action. I am here today to express my opposition to the Human Rights Sanctuary Amendment Act and the Enhancing Reproductive Health Protections Amendment Act. Abortion is the leading human rights atrocity of our time, with over 63 million preborn deaths since 1973. At Students for Life, we believe human rights begin in the womb, and even the voiceless in the womb have rights worthy of our protection. Just as Councilmember Nadeau's letter states, we too believe people, including the preborn, should, quote, flourish as meaningful participants in American life, unquote. These pieces of legislation before you today, specifically the Enhancing Reproductive Health Protections Amendment Act of 2020, would be a roadblock in our legal system, which was set up to hold perpetrators of the law accountable and not to enable illegal behavior. Adding these amendments and furthering abortion violence does not legislate other issues that leaders need to take up. Furthermore, the science is not on the side of the chemical abortion pills. We know that getting rid of health and safety standards for chemical abortion is anti-women and anti-science. These pills cause 4 times the complications as surgical abortion, with a risk of death that is 10 times higher, according to an NIH study. The Human Rights Sanctuary Amendment Act of 2020 works to streamline access to chemical abortion pills, but we know that the FDA has reported numerous side effects of these risky pills. Between 5 to 7% of women who take chemical abortion pills will need a follow-up surgery to end the pregnancy. An Australian study noted that up to 8% of women who took the pills in that country ended up in an emergency room. Chemical abortion pills don't work well later in pregnancy or when a woman has an ectopic pregnancy. The FDA also notes that such pills present a risk of death from internal bleeding caused by a ruptured ectopic pregnancy, making a clear case as to why these amendments shouldn't move forward. These issues that I speak about today are very personal to me. I was adopted from China as a toddler, and I stand before you today as a survivor of China's one-child policy. This policy was responsible for and indirectly took the lives of millions of little girls and women and babies through abortion and violence and infanticide. Today, July 14th, is the anniversary of when I was abandoned on a street in Guangzhou to die. The late-term abortion policies of our city rival those with horrific human rights abuses such as China and North Korea. Please do not only see me as a representative of Students for Life for America, who I proudly work for, but also as the little girl that was left in a box with a piece of paper bearing my name and birth date over 20 years ago. My mother did not end my life because she knew that my preborn life had meaning and value, despite the lies told to her that abortion is an easy way out. I survived, but sadly, far too many of my generation are gone. I must ask you, how much is a child like me worth? I'll ask you again, members. How much is a child like me worth? Instead of passing legislation that has practically no limits on abortion or safeguards for the health of women, we must protect all women and children from the violation against their human dignity. Please help protect the preborn from these predatory abortion industries by voting no to stop these amendments. Thank you very much for allowing me to speak.
Thank you very much. Our next witness is Maddie Feldman. Welcome.
Hello, thank you, Chairman White and members of the DC Council's Committee on Government Operations and Facilities. I appreciate this opportunity to appear before you today to speak on behalf of a variety of DC-based youth social justice groups, namely the Student Action Committee, as well as the Sexual Assault and Consent Summit, as well as the Reproductive Justice arm of the Temple Sinai Youth Social Justice Group. As a recent high school graduate of Georgetown Day School, who was born and raised in DC, Ward 3, I speak personally when I say the right to protect abortion has galvanized my generation. Why is that? Because being born in this 21st century, being born in 2004 in DC, our right to reproductive health and abortion practices has never in our lifetimes been threatened to this degree. We, the District of Columbia, must do everything in our power to provide support to healthcare professionals and all those seeking abortions, not only to set a precedent and regional mandate to encourage like-minded states to follow suit, but also to protect the 800,000 district constituents whose bodily autonomy is threatened at the hands of national leaders. All it takes is a Republican majority in Congress to usurp district policies and stop the city from subsidizing abortions for low-income women. And because DC is not a state, and since Congress retains exclusive control over the city's operations, even our implemented laws have the potential to be compromised. For that reason, reproductive justice has become an issue of DC statehood. We've seen the ramifications of our lack of autonomy before, even just recently with January 6th, when the insurgency propelled Mayor Bowser to request support from the National Guard. But because DC is not a state, that request had to be approved by the Defense Department and then the president. That meant that DC was left having to request intervention from states that have unilateral power to mobilize, Maryland, Virginia. And just like our defense system, our healthcare system has the potential to fall under the whim of the national president every 4 years, especially if we do not institutionalize practices that protect individual self-managing abortions and prevent DC from cooperating with out-of-state investigations, as prescribed in B240726 and B240808. And now, in response to a few previous testifiers, I also want to explore the legal argument that backs this legislation, or really that doesn't back the contrary. There are two ways a pro-life law operates: one as a protection of actual life, and two as a protection of potential life. And the former does not apply here because there exists no scientific standard for when life begins. Instead, there's a series of individual values, systems, and the government has no place to arbitrarily pick one system that's unconstitutional. The scientific standard for when life begins is fundamentally unprovable. And second, as a law as a protection of potential life also does not apply because there cannot exist a constitutionally based standard of potential life that has any legal value. And thus the protection of potential life opens the precedent floodgates to any and all potential life being protected. Anti-abortion arguments are not necessarily wrong, but they're not legally feasible. And whether or not the unborn is a person, it's not a legal person. To clarify previous arguments, this is not an abortion mandate that DC is working to pass. It's increased access to abortions. It looks nothing like a one-child policy, for example. So in keeping in mind the precedent that DC must continue to set, as well as the lack of legal argument for the legislation's opposing sides, and also in acknowledging the thousands of DC students, high school, middle school, elementary school students who have joined me in protest against the recent Supreme Court turning and in support of protection and choice, I'm firmly in support of these two bills. Thank you.
Thank you very much. Our next public witness is Ellie Levenskew.
Good afternoon, DC Council members. My name is Ellie Levesque. I am a resident of DC, a student at UDC David A. Clark School of Law, and a member of my law school's If When How chapter. Thank you for allowing me to speak to you all in support of Bill 24-726 and Bill 24-808. Just 2 weeks ago, I moved here from Florida to pursue my Juris Doctor degree, specifically focusing on reproductive law. I've been doing reproductive justice work for the last 3 years, mobilizing young people and students in the Tampa Bay area. This is really my life's work. At 23 years old, I am a young queer woman with the rest of my life ahead of me. With the overturning of Roe and Casey, my future is at stake along with the futures of young people across the country. The decision about whether and when to become a parent is one of the most important life decisions that we make. When people can make decisions that are best for their lives, families thrive and we are able to build communities where each of us can participate with dignity and equality. Over the last few months, 2 major abortion restrictions have gone into effect in my home state: a 15-week ban and a mandatory 24-hour waiting period. These laws are medically unnecessary and unconstitutional. Florida has been a safe haven for people living in the South, as many surrounding states have limited access to abortion care. Since we now have more restrictions imposed on patients in Florida, people living in the South will need to go elsewhere to receive abortion care beyond 15 weeks of pregnancy. Preserving and protecting abortion access for these individuals is vital. When abortion care is unavailable, the harm falls hardest on those struggling financially or those who already face significant barriers to healthcare. Reproductive health care is already out of reach for many people with low incomes, young people, LGBTQ+ people, the trans and gender expansive community, and people of color. We must work to ensure access to healthcare does not depend on who you are, where you live, or how much money you make. As someone moving to DC from a state that is blatantly disregarding its own constitution and enacting egregious abortion restrictions, I am excited and eager to see what abortion protections could look like here and in other states. This is no longer a matter of simply keeping abortion care legal. That is not enough and will never be enough. States now have the responsibility of expanding and protecting access to abortion care, as well as protecting those who support and provide that care. The Enhancing Reproductive Health Protections Amendment Act of 2022 and the Human Rights Sanctuary Amendment Act of 2022 do just that. I urge you to advance these bills. Thank you for your time.
Thank you very much. Jean Throw, welcome.
Good afternoon, and thank you, Chairman White, Councilwomen Henderson and Nadeau. My name is Jean Throw, and I'm a resident of the District of Columbia and a member of Friends Meeting of Washington, the Quaker meeting in the DuPont Circle neighborhood. I would like to speak in support of the Enhancing Reproductive Health Protections Amendment Act of 2022 and the Human Rights Sanctuary Amendment Act of 2022. My faith is important to me, and I've always supported a woman's reproductive rights since long before the U.S. Supreme Court struck down Roe versus Wade. I am thankful for my faith community that supports my decision, as you will hear from my dear friend Martha Salt in a little bit. This issue is very important to the women in my family. My sister has had 2 ectopic pregnancies, and thanks to her physicians, she was prevented from dying by aborting the 2 pregnancies, which would never have come to term, but certainly would have killed her and in the 2 pregnancies. These pregnancies were not planned and were after her 2 children were adults. My niece, my sister's daughter, lives in Louisiana, a state that has already severely limited women's reproductive choices. Jackie is 32 and already has 3 daughters. Lacey is 6, Anna is 4, and Ivy is 2. Last year, Jackie was diagnosed with stage 4 breast cancer. She was told to get her affairs in order, that the diagnosis was not good. As a tough as nails Southern woman, she has been able to get her cancer into remission, but has been told she cannot get pregnant due to the effects pregnancy would have on her hormones, which would then cause her breast cancer to return. After 3 days of contemplation, I contacted my niece and told her if she gets pregnant, I will help her get an abortion in DC, if that is her choice. Those that know me will tell you how much I follow the rules. I get annoyed at those who flaunt the law. However, due to my conscience, I am prepared to go to jail for my niece. I would rather Jackie live a long, happy life raising her 3 very spirited children than those girls grow up without their mother. I'd also like to add, my Catholic parents support my choice. These bills protect me as a citizen of Washington, D.C., being a help to my family. I cannot express my gratitude enough for both of these pieces of legislation. I urge the City Council to pass these bills into law. Thank you.
Thank you very much. Martha Salt, welcome.
Good afternoon. Thank you for allowing me to testify. My name is Martha Sold, and I serve as the clerk of the Marriage and Family Relations Committee of the Friends Meeting of Washington, also known as Quakers. And I'm, of course, a very good friend of Jean Throw, who is a wonderful resident of DC. Quakers have had a continuous presence in Washington, DC since the early 1800s, and we've been at our present location on Florida Avenue Northwest since 1930. We have a deep commitment to our home in the District of Columbia. Our religion requires us to apply moral and religious values to our own lives. The Friends Meeting of Washington has adopted a statement of faith related to issues of reproductive health. A Minute on Privacy and the State, May 2022, which reads in part, Friends believe that there is that of God in every person, and that the spiritual journey is one of continual seeking and revelation. Often life brings us to difficult, meaningful moments of decision-making. We are taught to hold these decisions in the light, seeking guidance by spirit. Often we turn to our community for help in gaining clarity. We know and respect the individuality of each person's spiritual journey, knowing that decisions can lead to both endings and beginnings, often in unexpected ways. The decision to have or not have children and the decision of who to marry or not marry are examples of deeply personal, individual decisions to be made by the person or people involved in the presence of the Spirit. Friends believe that all families have privacy rights and people of all genders have rights to reproductive health care, including pregnancy termination. In order to practice our faith, we and others need access to safe and legal reproductive health care. As such, we fully support both B-24-726, the Enhancing Reproductive Health Protection Amendment Act of 2022, and B-24-808, the Human Rights Sanctuary Amendment Act of 2022. Thank you, and I'd be happy to answer any questions.
Thank you very much. I want to thank this entire panel. Not sure if my colleagues are still with us. Councilmember Henderson.
I am still here. Thank you, Councilmember White, and thank you to the witnesses who testified and provided testimony here. Ms. Anderson, Victoria Anderson, I just wanted to say, I think you brought up a really good point in terms of not necessarily specific to DC, but the impact in other jurisdictions like Nebraska and the rural areas, where there's limitations in terms of even, facilities. I was reading a study last night that was talking about 1 in 6 hospital beds in the United States are at Catholic facilities. And they were sort of speaking to how that impacts care in general, and the overall health space around that. So I wanted to say thank you for that. I also appreciate having younger voices in this conversation. And so thank you to Ms. Feldman. I think you might have testified at something else before, because I've seen you before. And so I appreciate your activism and your very well-constructed testimony here. And even Ms. Faith, even though we disagree on this issue, I appreciate your willingness to testify and your engagement on this issue. That's all I have. Thank you so much to everyone again.
Thank you very much, Councilmember Nadeau.
Just want to thank everybody for their testimony. Thank you, Chairman.
Thank you. I want to join my at-large colleague in thanking everyone, but particularly our younger witnesses for engaging in this dialogue and respectful debate. So thank you all for being with us in this hearing. We will move to our final witnesses, Advisory Neighborhood Commissioner Salim Adolfo, ANC HC07, Commissioner Peter Wood, ANC 1C03, Commissioner Trupti Patel, ANC 2A03, and Commissioner Travis Swanson, ANC 7B03. And we will also have Renee Bracey Sherman on this panel as well. Commissioner Adolfo, if you are with us, I would ask you to turn on your camera. Let's start with Renee. Sorry, I'm missing your name. Renee Bracey Sherman.
Hi.
Welcome.
Hi, how are you? Thank you so much. Good afternoon, everyone. My name is Renee Bracey Sherman. I use she, her pronouns, and I speak to you today as a very proud resident of Ward 7, the executive director of We Testify, which is an organization dedicated to the leadership and representation of people who have abortions, and, as my shirt says, someone who had an abortion. Thank you so much for allowing me to speak to you today and for your bold leadership in the wake of the Supreme Court ruling that overturned Roe v. Wade. This is a really scary moment to need an abortion in this country. Every day, another state is criminalizing abortion and allowing complete strangers to sue those of us who have abortions and the people who love and support us, even when we are faced to travel to other states for care. Many people, as you've heard from other witnesses, travel here to DC for abortion care throughout their pregnancies. I know this because I volunteer several times a week to pick them up at the airport and take them to the clinics here in the city. And while that work has always happened due to the decades of restrictions on abortion access across the nation, the emails I and other volunteers receive, like Steph Black mentioned earlier, now often come with warnings that we could be sued or prosecuted for simply helping someone in need by giving them a ride to their hotel or their abortion appointment. I cannot think of anything more unloving than to criminalize people who offer a loving, helping hand. The reality is many people are unable to receive care from a provider in their community. And while some won't be able to shoulder the financial and logistical burden of traveling out of state for care, those who can will and do come to Washington, D.C., and we must remain an open and welcoming community. The wave of grief and fear and confusion has swept the country, but the Enhancing Reproductive Health Protections Amendment Act and the Human Rights Sanctuary Act serves as a guiding light to protect access to self-managed abortion in D.C. Washington, D.C.'s move to protect people who self-manage their abortions and the people who help them is the tide turning, meeting the moment that I hope more cities and states move to do to ensure that everyone within their borders is protected no matter the outcome of their pregnancies. We need clinics in our communities in Washington, D.C., and pills in our hand. We have the power to ensure people know about self-managed abortion resources and are not criminalized for using them or helping people who choose to self-manage. Self-managing an abortion is medically safe and common all around the world. Research shows people are able to have abortions on their own with medication, and in fact, it is one of the safest medications that we have. But what is risky is the criminalization of people for seeking their own health care. The people who are most likely to be criminalized are disproportionately Black and brown people, those who don't have the money or means to protect themselves. I do not want more criminalization of Black and brown and queer and trans immigrants and sex workers, all of my neighbors in Washington, D.C. I am so thankful to Councilmember Christina Henderson and our team for showing up for us as D.C. residents and for people who have abortions. It's wonderful when our elected officials listen to the needs of people in their district and show up with real solutions to protect our access to healthcare, including abortion, in this moment and beyond. We can create a world where all people have the power and resources to care for and affirm their bodies and identities and health for themselves. I don't know where I would have been without my abortion. I know I considered self-managing with really dangerous methods. It's really important that we show people what the safe methods are and protect them from criminalization in Washington, D.C. Thank you so much.
Thank you. Commissioner Peter Wood.
Hi, good afternoon. My name is Peter Wood. I'm an advisor neighborhood commissioner in Adams Morgan and a firmly pro-abortion resident here to support both the bills we're discussing. I'd like to detail some work I've done the past few months, unifying ANCs across the city around this issue, But first, let me elaborate on why ANCs are so invested in the first place. The list of reasons why access to abortions must be unimpeded is long and well articulated. Some of the more prominent discussions focus on instances of rape, incest, and sexual abuse, where offering access to an abortion is a moral obligation by society. Similarly, domestic violence is often intricately woven with the need for abortions. That's true in cases of physical threats, but also relationships where coercion, emotional manipulation, and other forms of exploitation like financial control are predicated on an imbalance. One person can dictate if another person has to gestate a fetus, regardless of whether that person wants a fetus inside them, wants to care for that fetus once born, or if the person who impregnated them is willing to assume comparable responsibilities. Situations like these, where abuse and violence occur, are crucial points of focus, but the line isn't drawn there. Even in scenarios where sex is consensual, relationships are healthy, and resources exist to raise a human being from birth, access to abortion is a fundamental necessity. If someone wants an abortion, they should be able to get one. End of story. Unfortunately, we all know our reality in the United States is far from this ideal. Childcare is expensive and often inaccessible. Maternity and paternity leave are laughably short and underfinanced. People die during childbirth at a much higher rate than in most of the quote unquote developed countries of the world. Even just socially, our cultural fabric often implies that once a child is born, your identity must shift from person to parent. There are also macroeconomic elements to consider. For years, researchers have demonstrated that access to education is one of the most vital factors for empowering women and improving the quality of life in a given community. The underlying reason? Because autonomy matters. Access to information, which can inform one's ability to make decisions for themselves, is the foundational premise for free people. This is the standard we need to uphold. Just as with education, access to abortion is a fundamental element when codifying a person's autonomy. While the comparison warrants qualifiers, namely that not all women can get pregnant and not everyone who can get pregnant is best labeled as woman, the point remains the same. Autonomy matters. Beyond the invaluable reflections of healthcare practitioners, patients, and policy experts, one area of work that is worth mentioning comes from, oddly enough, my background as a geographer. There's some research which suggests, among many other things, that abortion lowers crime rates, but that really just addresses a deeper, more abstract concept, something which academics call biopolitics. Much like how political refugees are stripped of their status as autonomous human beings, denying access to abortions is state violence. It puts childbearers at risk, it contributes to rises in suicide rates, and it infringes on the right, so ironically encapsulated by that famous yellow flag with the rattlesnake, to not be tread upon. Again, autonomy matters. Those of us in the District of Columbia know this incredibly well. Liberty is only real when self-rule has no strings attached. The fight for statehood trudges onward, and this chapter of the story reinforces the need for local leaders to step up. That's why scores of ANC commissioners have risen to the occasion and passed resolutions in support of today's bill. I have a longer summary that I'll send in written form, but just to briefly summarize the main points from the resolution that I've circulated. We urge council to pass these bills and others like them. We urge DC government to make it widely known that DC is a safe place to get an abortion. And we urge DC government to make sure people can safely travel to and from places where they get abortions. I've been personally in contact with all 39 ANCs that currently have quorum, working together to demonstrate that DC's most hyper-local representatives overwhelmingly understand what's at stake. And the numbers are still changing, but my latest count is that at least 19 ANCs in DC have passed this resolution that I've mentioned or something similar to it, at least one in all 8 wards, and many others have this resolution on their next meeting's agenda. So just to close with a summation of the spirit of our text, healthcare is a universal human right. Abortion is a common, safe form of healthcare. Abortion is legal and protected in Washington, D.C. Let's keep it that way. Thank you.
Thank you. Commissioner Trupti Patel, welcome.
Good afternoon, Councilmember White. Thank you for hosting this hearing so that our comments can be entered into the public record. As a woman in the United States, I am now a second-class citizen that represents an area that should be a state, but isn't due to the whims of a group of people who justify that DC doesn't need representation. Sound familiar? It's the pervasive theme. Being told what to do and how to do it because of your status or sex. We talk about the importance of freedom and liberty, but yet I live in a nation that has told any individual with a uterus they don't have They don't have that. We don't have them and we don't possess them. DC is at a defining moment. We will continue to protect a woman's right to have privacy, to make intensely personal medical decisions. As the news would leak that the Supreme Court stripping the ability to decide to have a safe medical procedure, I, along with hundreds, would take to the streets. Many of my ANC colleagues were there in solidarity. My previous one, Peter Wood, who just spoke, reminded of the sacred oath we all took when we got elected. I'm here to unapologetically defend and protect not only my right to choose choices impacting my medical health, but every individual rights to do so. I have one more page. This is not about morality or religion. It boils down to subjugation and controlling of a population of people. A nation that permits guns to have more rights than myself is not how we should be leading. The moment we slept on our rights is when the US has lost its title of being the greatest nation on earth. A sign of greatness is not control, but to trust the people to have the right to make choices that are the best for their lives at any point, no matter what the circumstances. One of the most sacred things that separate human beings from animals are the following: the ability to think, the ability to evolve, the ability to choose. When you take away the concept of choice from people, you have stripped them of their humanity, and it is now a human rights issue. Abortion is a gender justice issue. Abortion is an economic justice issue. Abortion is a racial justice issue. Abortion is a medical justice issue. I urge you for these reasons to support B240726, Enhancing Reproductive Health Protections Amendment of Act of 2022, and B24-0808, Human Rights Sanctuary Amendment Act of 2022. Thank you.
Thank you very much, Commissioner Travis Swanson.
Good afternoon. I want to start by saying thank you to Council members Christina Henderson and Brianna Nadeau for bringing these important bills forward, and to Councilmember Robert White for holding today's hearing. My name is Travis Swanson, and I'm the commissioner who has the honor and privilege of representing ANC 7B03, which includes parts of the DuPont Park, Fairlawn, Randall Highlands, and Twining neighborhoods in Ward 7. I'm here today to express my strong support for both the Enhancing Reproductive Health Protections Amendment Act and the Human Rights Sanctuary Amendment Act. With the Supreme Court's recent decision to ignore nearly 5 decades of precedent by overturning the 1973 Roe v. Wade decision and leaving a patchwork of laws across the country, it has left DC in a unique position to essentially start serving even more people than we have in the past. Even before the Dobbs decision, DC has been lucky to have specialized abortion providers in our city. So it's no stranger to have people traveling from other states to DC to seek the specialized care they were unable to seek in their home state, even prior to Roe being overturned. In fact, 60% of all abortions performed in the district were from out-of-state patients, and that was pre-Dobbs. Post-Dobbs, this number is expected to grow substantially as people from states with abortion bans are now required to travel across state lines to meet their healthcare needs. In addition to abortion bans in many states, they are also considering legislation that would make it illegal for their residents to cross state lines to seek abortion care. The US Constitution and the Supreme Court has recognized and protected the right to interstate travel in our country. However, we've seen that precedent doesn't necessarily mean much with this court, and it's very unfortunate and very common for people to have to travel out of their home state to access medical procedures they can't in their home state obtain for one reason or another. And this can be everything from surgery to cancer treatments and, yes, abortions. If someone chooses to come to the District of Columbia for their abortion care, no matter where they come from, they made the decision that they felt was right for them. And if their home state tries to penalize them, DC should not assist them in that investigating a crime that under DC law didn't even occur. DC taxpayers should not have to foot the bill for a fishing expedition of other states looking to cruelly criminalize their residents for traveling to access healthcare that was unavailable to them in their home state. Today, I've been watching this hearing since it started. Several doctors, no less than half a dozen from my count of watching this hearing, though I've been working also, so potentially more, have testified as to the history, importance, and safety of self-managed abortions. These doctors are all respected professionals in their field, and they are subject matter experts on the subject at hand. When passing laws around healthcare, it's critical that we trust the experts. And today we have seen overwhelmingly that the experts in their field say this legislation is good policy. I would close by saying that I hope when making laws and decisions around medical procedures and hearing testimony from medical providers that are backed up with their education, their experience, and the respect in their field, that's being countered only by personal opinion, that what the providers say and the subject matter experts say would prevail in this committee every single time. Thank you for your time, and I welcome any questions from the committee.
Thank you. We have one final public witness, Robin Tucker.
Hello. Thank you, Chairman White and members of the council. My name is Robin Tucker. I am a certified nurse midwife and women's health care nurse practitioner. I am the treasurer of the DC affiliate of the American College of Nurse Midwives. I am also the owner of a reproductive health and gynecology practice here in DC. And I provide telehealth abortion through Aid Access, and I'm also a DC resident. The DC chapter of the American College of Nurse Midwives strongly supports both of these bills. DC is in a unique position of being one of a few states considering enhancing abortion protections, but we do have a few barriers that we still need to address. The DC SHPDA currently requires a certificate of need for any clinician offices to be permitted to prescribe medications for abortion. Due to this barrier, for example, I am unable to provide prescriptions for these medications through my private practice in DC, and I have to maintain a second business office in Maryland for these patients. The barrier means that the only entities and providers in the district that can prescribe medication abortion are larger facilities, which directly drives up the cost of this due to the facility fees being included in those procedures, and it compromises access by limiting the number of providers who can meet this need. Please consider adding parameters to this legislation to remove the certificate of need requirement for independent medical offices to prescribe medications for abortions. Considering the position of the DC Council that abortion is a human right, these barriers are wholly inappropriate in the district and more in line with states that desire to restrict access to abortion in general. I think that is all I had to say. Thank you very much to the members of the council and to Chairman White.
Thank you very much. I want to thank this panel, and we may have some questions. Councilmember Henderson.
Thank you, Mr. Chairman, and thank you to this panel of witnesses. I'm going to break it up because I have something I want to say to the commissioners and to the two public witnesses. First, to Ms. Bracey Sherman, I want to say thank you so much for reaching out to my office a few months ago about this, and for the dialogue and willingness to sort of be proactive in this approach around enhancing protections that we have for DC residents. And so I want to say thank you publicly for that. Ms. Tucker, I would say thank you so much for your testimony, although it's a completely different committee who deals with the certificate of need piece. And I feel as though Chairman Gray might have some issues. I will tell you that a couple of weeks ago, I did actually have a very in-depth conversation with the director of the State Health Planning Development Agency around certificate of needs, telehealth, and specifically as it pertains to reproductive health. And happy to sort of continue that conversation. We were talking very specifically about an out-of-state provider who was seeking to provide care in the district, but perhaps there might be something a little bit different for providers who are here in DC, who are already licensed here in DC. But if you want to talk about that offline, please feel free to reach out to my office. Happy to sort of facilitate that conversation, because as I'm a member of the Committee on Health as well.
Great, thank you, ma'am.
Yep. Commissioner Wood, I want to say thank you so much for spearheading the effort around the ANC commission, or the various ANCs in support of this. It is always heartwarming to get those notices. I do look at the notices when your ANC send them in terms of resolutions that have been passed. And so I appreciate your work on this. I appreciate Commissioner Swanson as well as Commissioner Patel, who had testified, but I think had to run. It is just really affirming to know that our elected officials who are the closest to neighbors are in support of this and are pushing us forward. So thank you to all of you for testifying. Thank you, Mr. Chairman.
Thank you. Councilmember Nadeau.
Thank you. I want to echo the gratitude to our ANCs. So thank you for that. And thank you for all of the testimony from our public witnesses. Thank you, Chairman.
Thank you very much. Same. I want to echo the gratitude and thanks, and also note for Ms. Tucker that my committee staff will follow up with you about your recommendation, and also has let Councilmember Gray's committee director know about it as well. So expect us to follow up with you. But I want to thank all of you for being a part of this important hearing.
Thank you.
Thanks so much. We will now move to our government witnesses. Now we'll welcome Attorney General Carl Racine and any members of his team who will be participating or presenting testimony or answering questions. Good afternoon, General Racine.
Mr. Chairman. Good afternoon, Mr. Chairman. With your indulgence, we're probably needed just about another 5 seconds to organize the framing.
No problem.
Oh. All right. Thank you for your indulgence.
Thank you.
Councilmember White.
I'm sorry, General Racine, before you begin, it is the practice of this committee to put our government witnesses under oath. Thank you. Do you swear or affirm under penalty of perjury that the testimony you're about to provide to the Committee on Government Operations and Facilities is the truth, the whole truth, and nothing but the truth?
I do.
Thank you so much. You can begin.
Thank you. Thank you, Chairman White and committee members for holding this hearing today. And thank you to Council members Nadeau and Henderson for introducing this important legislation now before the committee. As the district's chief legal officer, I'm responsible for enforcing the district's laws, defending the district's policies, and advancing the public interest. These three core responsibilities converge when it comes to maximally protecting reproductive rights in the district, because the overwhelming majority of DC residents emphatically and resolutely support reproductive freedom. As you know, during my 7.5+ years as AG, my colleagues and I have placed a special emphasis on ensuring that our laws and policies protect those who are often marginalized. And I want to be clear, the Office of Attorney General will continue to partner with the council, the mayor, and other stakeholders to defend and protect anyone who seeks an abortion in our city. Last month, the Supreme Court overturned a precedent that had stood for nearly half a century and eliminated the constitutional right to abortion recognized in Roe v. Wade. This right not only enabled women to control their reproductive lives, but it also undergirded a host of other rights we rely on today, such as the right to marry the partner of our choosing and the unabated right to contraception. With these rights now imperiled, we know who is most at risk: women, people of color, low-income individuals, people with disabilities, and members of our LGBTQ+ community. It bears reminding that our office has participated in more than 50 legal actions nationwide to defend reproductive rights across the country. And in advance of the court's decision in Dobbs, OAG has been working with legal experts, healthcare providers, district agencies, and the council to shore up our local policies on reproductive rights. And it is why I signed a pledge along with 82 other attorneys general and elected prosecutors, promising not to use the resources of the Office of Attorney General to punish people who receive or provide abortion services. OAG will do everything in our power to fiercely defend and strengthen the right to abortion in the district so that everyone can create their family how and when they choose. We'll defend abortion providers who offer needed care to support the health, safety, and dignity of their patients, and we welcome the creative thinking that the council members and staff will undertake to meet this moment. We all have a role to play here, and we invite the collaboration of district residents, advocates, and all district government leaders as we ready for the fights ahead. Now I'd like to invite our policy director, Kate Blatch, to provide more detailed testimony on behalf of my office. Kate is leading our office's work on reproductive rights, and you should know that in addition to being an extremely talented lawyer and policy professional, Kate has long fought for reproductive rights, including working for 10 years for the DC Abortion Fund, an organization, as you know, ensures that people have the resources to access the health and medical care they seek. With that, it's a pleasure to introduce you to Kate Blatch.
Good afternoon, council members. Do you need me to swear in, or can I go under the auspices of the Attorney General?
I will swear you in. If you would raise your right hand, do you swear or affirm under penalty of perjury that the testimony you are about to provide to the Committee on Government Operations and Facilities is the truth, the whole truth, and nothing but the truth?
I do.
Thank you.
Thank you, Councilmember White and committee members for holding this hearing today. And thank you especially to Council members Nadeau and Henderson for introducing the legislation now before the committee. I, as the Attorney General said, am Kate Blatch, and I have the privilege of serving as Policy Director for the Office of the Attorney General, or OAG, as you'll probably hear me say. Recognizing that the bills before the committee today represent just a fraction of the measures under development to shore up reproductive rights and LGBTQ protections, I will confine my remarks to the Human Rights Sanctuary Amendment Act, or the Sanctuary Bill, which proposes a creative approach to the novel legal landscape we now face. As the Attorney General explained, our office steadfastly protects the rights to abortion, contraception, same-sex relationships, marriage equality, and transgender inclusion, both here in the district and nationwide. We enforce the Human Rights Act to stop discrimination locally and have filed lawsuits and participated in dozens of amicus briefs and federal rulemakings on these subjects nationally. On behalf of OAG, I am pleased to express support for the Sanctuary Bill and its animating principles, which protect the rights of people in the district to make reproductive decisions, to access gender-affirming care, and to build a life with the partner of their choosing. The district has long protected more rights, not fewer. For decades, the district has been a national leader in recognizing and protecting civil and human rights for residents and visitors. For instance, safe and legal abortion has been accessible in the district since 1971, which is 2 years before Roe versus Wade. And we've welcomed district residents and women from across the country to receive this care for more than 50 years. The council has remained so committed to protecting abortion rights that it actually proactively stripped an inert abortion restriction from the books back in 2003. Although the restriction had not been enforced for decades, the council stated that it did not want to confuse people as to their rights, nor provide an opening to, quote, selectively and arbitrarily punish people for offenses that are now recognized as discriminatory or inappropriate, end quote. Instead, it clearly declared that abortion is not appropriate for criminal sanction. Similarly, the district was one of the first jurisdictions to legalize same-sex marriage, and for more than 30 years has recognized domestic partnerships regardless of gender. The district agency that registers these partnerships emphasizes that this recognition is available to all couples regardless of their place of residence. And the district has been a leader in affording protections for sexual orientation and gender identity. In fact, our Human Rights Act has prohibited discrimination based on sexual orientation since its enactment in 1978, and protected the rights of transgender people for nearly 2 decades before the federal civil rights laws were interpreted to do so. This sanctuary bill continues the district's tradition of guaranteeing freedoms to all people in our city. I won't spend too much time describing this bill to you. At this point, that territory is well trod. I offer a more fulsome explanation in my written testimony, but for now, I'll say that the sanctuary bill clarifies reproductive rights and LGBTQ+ rights in the district, and it insulates our local policies from out-of-state interference that could harm the very people our policies are designed to protect. Protections like these have become even more critical in the wake of the Supreme Court's decision in Dobbs v. Jackson Women's Health Organization. Again, I don't have to tell you what that decision did, but it's important to note that not only did it topple the constitutional right to abortion, it imperiled numerous other rights like contraception and marriage equality that rest on the same constitutional underpinnings. So given these threats, we must ensure that these rights are clearly and strongly protected in local laws. But even before the Dobbs decision, some states advanced restrictions that could interfere in new ways with the rights that are protected here in the district. And that interference could happen either explicitly or by raising uncertainty, which chills the local exercise of rights. Again, you've already heard about Texas's abortion ban that imposes penalties of no less than $10,000 on anyone who assists with abortion care in that state. And you may have also heard other states mentioned, including Idaho, that has enacted an abortion ban modeled on Texas law, and at least 15 other states that have considered similar measures. Although by their own terms, those statutes only punish abortions in the states where they're enacted, a motivated plaintiff may try to pursue a doctor, an abortion funding volunteer, or a nonprofit organization that assists with an out-of-state abortion. And although the target of such a suit likely would ultimately prevail, it would come at a cost of tens of thousands of dollars in attorney's fees and many hours spent defending the case. So it is understandable then why a driver, doctor, or aid organization might be reluctant to offer services in the face of such uncertainty. And indeed, as I will discuss shortly, these laws are already having a chilling effect on people in the district. With each new state abortion ban, we see additional questions that will prompt caution and chill conduct here in the district. Although the laws enacted thus far do not seem to extend to abortions obtained outside those states, some proposals would explicitly punish individuals who exercise their rights in other jurisdictions. For instance, the Missouri legislature considered a measure that would have allowed lawsuits against people who merely provide information or help someone in need travel to a place where abortion is legal. All of this with the express aim of targeting out-of-state abortion providers. And luckily, although the Missouri proposal did not become law, states could enact laws in this mold in upcoming emergency legislative sessions, which are being convened as soon as this summer. In fact, just last week, Texas legislators promised to pass a new law punishing abortion-related travel. And these are the types of laws that would directly infringe on rights and healthcare practices in other jurisdictions. And these are the types of laws that create the need for the stronger protections we see here in the district. In my written testimony, I share stories of how these laws have already intruded into the exercise of reproductive rights here in DC, but you've already heard many of those stories today. So to avoid repetition, I will briefly say that OAG has held listening sessions with healthcare providers and nonprofit organizations that serve abortion patients here in the district. And at every turn, we have heard that this community needs more certainty about their rights, certainty that the sanctuary bill aims to provide. I'll again briefly say that patients have reported that they are, quote, terrified to travel here for care because they're unsure if they might face a lawsuit or jail time when they return home. And one local clinic actually told us that before the Dobbs decision, it typically spoke with about 250 callers a day. But on the Monday after the Dobbs decision came down, call volume doubled to 500. Some of these callers were scrambling to find new appointments after they were displaced from shuttered clinics, but many callers already had appointments at this clinic and were in fact seeking reassurance that it was still legal to show up for care. Doctors, nurses, and other healthcare workers are also mired in uncertainty, and they are straining under the weight of trying to track laws in their patients' home states. And finally, local nonprofit organizations that provide financial assistance to people who seek abortion services here in the district are also under threat. We heard from some of those folks today. There are also other organizations whose staff and volunteers we've spoken to, and they're fearful of the consequences they might face for aiding someone who needs an abortion from a restrictive state. In fact, for a time last fall, they were not sure if they could risk serving Texans or residents from states with similar laws, and they thus limited which staff could interact with those patients. And keep in mind that this fear arose even though Texas's abortion ban lacks the explicit extraterritorial reach that some other states have now threatened. So these are just some of the examples of the chilling effects that have already happened and that give rise to the need for the laws that we see today. Although we do not control the actions that other states will take, efforts like the sanctuary bill send a message to patients, providers, and helpers that we will do all that we can to protect them here in the district. We look forward to working with the council and all stakeholders to continue to refine and revise the bill to ensure that it will strongly achieve its aims. So in conclusion, I will end with saying that the Office of the Attorney General thanks the council for leading the way in responding to these challenges. Please consider us your partner in ensuring our community remains one where all people are safe and welcome. And with that, I will welcome any questions that you may have.
Thank you so much. Let me start with my colleague, Councilmember Henderson. Do you have questions for OAG?
Thank you, Chairman White. And thank you, Ms. Blatch and Attorney General Racine. Or I'm assuming the Attorney General is still in the room with you. Yeah. So, Ms. Blatch, in your testimony, you didn't specifically speak in terms of the Enhancing Reproductive Health Bill. And I know that the council staff and your office have been discussing, but I just want to get a couple of things on the record, as I think the record is going to be important in any legislation that DC is seeking to move forward on these particular issues, knowing that the legal space is going to be thorny for a bit here. But has OAG been monitoring what other jurisdictions are doing as it pertains to self-managed abortions or protections around self-managed abortions, given we know that or anticipate seeing an increased number of patients who are seeking that particular route of care?
Thank you for that question, Councilmember. I hope we'll have the chance to tell you more about some of the other work that we've been doing, but yes, it absolutely includes taking a look at the laws in other states, both proactive and affirmative protections that we can borrow from and learn from, as well as the kinds of restrictive bans that we're seeing coming down the pike. And as you're probably aware, there is a mix of legal treatment of self-managed abortion. The district has been a leader in protecting people who exercise that individual autonomy. We already have on the books, as you know, protections for people who want to self-manage their own abortions. And a host of other states have criminal restrictions that would punish and penalize people who are self-managing abortions. So there is a mix. We are keeping an eye on what other states are doing and certainly want to take best practices from them.
Okay, great. I mean, I think that you're absolutely correct. DC law already protects in terms of the individual who may be seeking to manage their self-managed abortion. But as we've heard witness testimony from some of the public witnesses, sometimes there's a cast of other supporting actors that are helping here, whether it be someone who is holding your hand sitting next to you, or, someone who goes to pick up a prescription or whatever that might be. And so I think that at least the thinking of my office in this is around those individuals, the supporting cast, especially seeing, as you described, for Texas, for instance, like I never thought in my lifetime I would have to see ride share companies like Uber and Lyft have to put out statements to basically say, we just drive you. What you do at the doctor's office, like, has nothing to do with me, once you leave my vehicle. But I think that it's a shame that we're having to think this way, but I think that's a little bit of what's happening here. There was a public witness who testified a little bit earlier I think she was from the DC Domestic Violence Coalition, talking about the area coercion and wanting to ensure, not even just with the enhancing reproductive health, but also the legislation that Councilmember Nadeau introduced as well, to ensure that we have language that provides protections around that. Have you all sort of looked at that piece and angle? And if there are any suggestions that you all have to provide some more narrow scope in terms of language, is that something that you all can provide to Councilmember White's committee as we move forward over the summer?
Yes, absolutely. And thank you for raising that issue. As you probably know, our office also prosecutes sexual abuse cases and works with survivors of those sorts of crimes. And so we have a real interest in ensuring that we are not providing safe harbor to folks who may be practicing reproductive coercion. And so we'd be very happy to work with your staff, with committee staff, to ensure that the language of the bill reflects your legislative intent, not to facilitate or provide any kind of shield to wrongdoers.
Okay, and so beyond that, besides that particular area of scope, are there other concerns that you feel like we should be aware of?
We're happy to work with you and your staff on reviewing the language to ensure that it's as precise as possible and that it accomplishes your goals. So we'd be happy to follow up either in writing or in subsequent meetings to help you achieve your aims.
Okay, great. And I welcome that. Again, like I said, I feel like this is one of those things where, and I know the director of OHR hasn't testified yet, but I'm going to go out on a limb here and say this is one of these situations where everyone is in agreement in terms of a goal. We just need to get tight in terms of the language of how we get there. It's so interesting. While we were sitting here, got a news alert. You were talking about Texas. I don't know if you've even seen this, but I got a news alert from Washington Post.
Is it good news or bad news?
Texas sues Biden administration over federal rules that require abortions be provided in medical emergencies to save life of mother. That's where we are. So when we're talking about some of these things, in your, legal knowledge and background, and maybe the Attorney General can also speak to this, some of these laws where it allows for residents of one state to go after residents in another state when they, what I would say probably don't necessarily have any real standing in the incident. Are there other types of issues where this has come up, or is reproductive health sort of a new frontier here where they are trying this avenue or route?
I think we really are on new legal terrain. We had nearly 50 years of precedent pulled out from under us, and we've seen evolving attacks on our rights. And so this does feel novel. But we are continuing to look for analogous situations and to learn from sort of what law is available. But to my knowledge, and again, it's not definitive, this does seem to be a new way of approaching restrictions on our reproductive rights.
Okay. Councilmember Wright, I know we're having some timer issues, but I've been looking at the clock, and so I think I'm done on my end. So I want to hand it back to you and say thank you to the Attorney General's office and to Ms. Blatch. Thank you.
Thank you very much, Councilmember Henderson. Councilmember Nadeau.
Thank you very much, Chairman. Thanks to the Attorney General's office. We've been working pretty closely on this legislation, so I do not have any questions for you. I will save mine for the Office of Human Rights. Thank you.
Thank you, Councilmember Nadeau. A few questions for you, Ms. Blatch. The sanctuary bill would prevent the district from participating in interstate investigations or proceedings against people engaged in certain activities that are lawful in DC. How often does your office cooperate in interstate investigations or proceedings?
Sure. So we do have a core practice of working across and along with our sister states on issues of importance to us. The primary subject matter that we tend to partner on tends to be antitrust enforcement, consumer protection, and to a lesser degree, environmental justice issues. But we do have a robust multi-state practice where we work in cooperation with other states on advancing our enforcement priorities.
If there's if a subpoena is issued from another state, I guess it may be challenging for our judges and the court clerks to tell whether a subpoena requested by another state or party would implicate this bill. Do you have any recommendations for how we deal with this, either as a legal or practical matter?
Yeah, so I've been thinking a little bit about how they practice, and it seems that the recipient of a subpoena, that was subject to the sanctuary bill could file a motion for a protective order or a motion to quash. But certainly that would require the involvement of an attorney. And I know that one of the concerns is about folks who may not have a representation or who may not be able to navigate the court system on their own. And so another model that you might want to think about looking at is the Superior Court's landlord-tenant practice, which is really designed for folks who are pro se or may not have a lot of money to spend on a lawyer. And there are a number of forms that folks can fill out on their own and file with the court. And so that might be able to serve a similar purpose to flag that a subpoena is one that the recipient considers to be affected by this statute. But I'm sure there are lots of other ways to borrow from existing practice that we could think through.
Okay.
Oh, and also the Attorney General would like to share some perspective as well.
Thank you so much, Kate. Mr. Chairman, the other point that I would contribute is that not unlike other laws that the council enacts that are novel or new, when that happens, we take it upon ourselves to appropriately work with the court to educate the court on an expansion of, say, the Consumer Protection Act or the civil rights laws or another law that may give rise to court action, so that they are aware of how these matters would originate. And certainly, should this bill pass, and we certainly are urging its passage, we too would go to the court and do as best we possibly can to educate the court on the full range of how these matters may arise, so that the court can take protective action to ensure that individuals who might be subject to process or otherwise at least have counsel, have the access to the Office of Attorney General to maximally protect themselves according to DC law.
Okay, so you'll work with the courts as this issue evolves and make sure there's as much possible clarity on the front end
Exactly.
Okay. Not sure if this would be best for you or Ms. Blatch, but both of today's bills would expand current language in the Human Rights Act, DC Code 2-1401.06, which prohibits government penalties for certain abortion-related related activities. One concern raised by a couple witnesses was whether this could be used as a defense if for generally prohibited context that happens to involve a pregnancy. And so in your reading of this legislation, could this be used as a defense for someone who tried to harm a pregnancy in some way that was unrelated to an abortion? This was a concern raised by a couple witnesses.
So that's something that we're taking a close look at, and we want to work with you and your staff and the authors of the bills, of course, to ensure that the language, is faithful to their intent. And I get the strong impression that it's not their intent to provide safe harbor to abusers or folks who are engaging in reproductive coercion. And so we will be sure to take a close look at the language alongside you all.
I appreciate that. Another concern that bears some attention raised by witnesses is sort of the need to ensure that only the best and safest abortion medications are getting distributed, and how to keep bad actors from preying on women who are in a difficult or vulnerable position. Do you have any recommendations on how we strike that balance or language we may want to add?
Yeah, absolutely. I think that that's a natural extension of some of the earlier concerns that we were talking about, where we want to ensure that our consumer protection laws and other protections remain in place, and that we have the full strength of our office available to deploy if needed. And so those are the kinds of adjustments and harmonizing that we want to make sure is front of mind as the legislation moves through the process.
Okay, we'll be happy to continue to work with you and the introducers of both bills on these issues. Slightly different issue, another one that did come up in testimony. The sanctuary bill would create a new mechanism for allowing people to go to court if someone secures a judgment against them in another state for protected conduct that is protected here. Do you have thoughts on that provision?
So, the clawback provision is what we've been calling it, is something that I've been thinking of in a way that's analogous to our anti-SLAPP statutes. And so it's not a perfect analogy, but the reason I've been using this as a comparator is that our SLAPP laws, our anti-SLAPP laws, recognize that lawsuits can stifle conduct that we care about, and we want to create some sort of extra legal process to buffer individuals from the effects of a retaliatory lawsuit. And so with those laws, briefly, SLAPP lawsuits, strategic lawsuits against public participation, are often filed to retaliate against whistleblowers or people who speak out on matters of public concern. And what the district has done and a number of other jurisdictions have done is to create an anti-SLAPP protection, which is basically creating a motion that someone who gets hit with a lawsuit can file that asks the court to pause the lawsuit and take a close look at whether in fact it is retaliatory. And that protection from the court gives the target of the lawsuit some measure of breathing room. It sort of pauses the meter on the attorney's fees, it pauses discovery, and ultimately it leaves it to the court to determine whether the lawsuit should move forward. So it's not a perfect analogy, but the reason that I think about it is that we have acknowledged that there are instances where lawsuits can chill or limit conduct that we care about, that we value, and that we want to protect. And we've looked to institute additional court processes that can provide some measure of insulation. And so I think of this provision as a version of that, and we'll we'll have to see how strong my analogy holds, but I think it's not unprecedented for jurisdictions to add additional court process to protect the rights of our residents.
I appreciate that. I appreciate that that analogy. Before we wrap up, is there anything else that you'd like the committee to consider in connection with these measures as we anticipate moving forward to a markup?
Yeah, so I would like to take the opportunity to invite the Attorney General back to just share a bit with you about the approach that we're taking to the new legal landscape we confront. So he's going to share with you a bit about sort of our holistic approach.
Okay.
Thank you so much, Kate. And I think the approach can be summed up here is that it takes a whole village. And we are working collaboratively first within the office with literally every section and every division in the office, seeking to identify ways in which it can participate in the protection of reproductive rights. That's first and foremost. Secondly, we've assigned Kate, who's put together a great group, including our Solicitor General's office and others, to really be right at the front of looking at the breaking news, as Councilmember Henderson saw, and studying the questions that are raised literally on a minute-by-minute basis. Quite apart from that, outside of the office, we're actively discussing with other state attorneys general, other city attorney offices who have similar values, what they're seeking and what they're seeing in the law as additional means to protect reproductive rights. And I think, as the breaking news suggests, we have to brace ourselves for the lawsuits that are definitely going to follow. And they will follow should this legislation, as I fervently hope, be advanced. And I think that so long as we're approaching the legislation in the collaborative way, developing the kind of record that Councilmember Henderson talked about, that we're going to be in strong position to defend district values in court. So to make a long story short, the full resources of the Office of Attorney General have been deployed in regards to working with stakeholders in every agency in the District of Columbia, including the council and the mayor, to educate the public and to defend DC residents when it comes to reproductive rights.
Thank you very much. I want to thank you for everything you and your team are doing here. It's an important time for the district, an important time in the country. And I'm glad that the council, the Office of the Attorney General, the Office of the Mayor are stepping up together and are in lockstep on this. So thank you all again. I want to make sure now that my colleagues have further questions before we move on. Excellent. All right, Attorney General Racine, Ms. Blash, thank you so much for being with us.
Thank you.
We will move to our final government witness, and I will welcome Director Nin Kine, Interim Director of the Office of Human Rights, and her team. Director, welcome.
Good afternoon, Chairperson.
Good afternoon. As you know, it is, do you have additional staff who may be testifying?
I do. I have with me our General Counsel, Andrea Goplerud, as well as, I believe, my Deputy Director, Mamadou Samba, will be joining as well.
All right. Well, I will wait for them to get on screen so we can swear everyone in together. Waiting for, there we are. Welcome, everyone. All right, I'd ask that everyone raise your right hand. Do you swear or affirm under penalty of perjury that the testimony you are about to provide to the Committee on Government Operations and Facilities is the truth, the whole truth, and nothing but the truth?
I do.
Wonderful. Thanks so much. Director, you can begin your testimony.
Thank you, Chairperson. Good afternoon, Chairperson White, Councilmember Henderson, Councilmember Nadeau, committee members, and the staff of the Committee on Government Operations and Facilities. My name is Ninh Kine, and I'm the Interim Director for the Office of Human Rights. Thank you for the opportunity to discuss Bill 24-0726, the Enhancing Reproductive Health Protections Amendment Act of 2022, and Bill 24-0808, the Human Rights Sanctuary Amendment Act of 2022. I'm so humbled to be here today, and I'm appreciative and thankful for the public witnesses today for their brave and moving testimonies. I want to begin by echoing Chairperson White, your statement earlier in the hearing that abortion and other reproductive decisions are lawful in the district, and the Human Rights Act protect against discrimination based on those choices. That said, the two bills today are timely and absolutely necessary to preserve our right to choose and make personal decisions in the District of Columbia, despite the Supreme Court's historic rollback of Roe v. Wade. On behalf of Mayor Muriel Bowser, I am honored to express the executive's full support of the bills and our commitment to working with the council to ensure the District of Columbia remains a place where we uphold our DC values, which include the right to choose the destiny of our bodies, parenthood, family planning, right to love who we want, and the right to express our identities consistent with our hearts, not with our assigned sex at birth. Moreover, we are committed in the district to ensure our government does not interfere with these liberties so that every individual, as the Human Rights Act intended, has an equal opportunity to participate fully in the economic, cultural, and intellectual life. Because the two bills today will work in tandem, I will discuss both together, but I will begin with reproductive health rights and move on to discussing other liberties under threat. The district has always been a thought leader in advancing human rights, and today is no different. As you know, in 2015, through the Reproductive Health Non-Discrimination Amendment Act, known as RONDA, the district amended the Human Rights Act and added anti-discrimination protections for employees facing reproductive health decisions. The U.S. House of Representatives attempted to strike down this bill, but fortunately, the disapproval resolution was too late and RONDA became effective May 2nd, 2015. In 2020, through the Strengthening Reproductive Health Protections Amendment Act of 2020, we made clear that our government would not interfere with an individual's personal choice regarding contraception, sterilization, and abortion services related to these, to treat employees who are temporarily disabled because of reproductive health decisions differently than other temporarily disabled employees. It also extended protections for healthcare providers who participate in abortion, sterilization procedures, or related training outside the course and scope of their employment. Building on these efforts, the bills today would protect those who support and assist individuals seeking to self-terminate a pregnancy and shield those who provide, dispense, or transfer any product used for self-managed abortions from penalties. Additionally, the Human Rights Sanctuary Amendment Act would guarantee the district would not cooperate with interstate investigations or proceedings attempting to prosecute individuals or entities for engaging in conduct made lawful in the District of Columbia. Further, the Sanctuary Act will enable a victim of such prosecution to seek a private right of action for damages resulting from the judgment of such prosecution. Though of different composition at a different time, the Supreme Court has said, and the dissenting opinion in Dobbs reminds us that no right is held more sacred or is more carefully guarded than the right of every individual to the possession and control of their own person. And the passage of the bills today will make sure we safeguard this right in Washington, D.C. Over 15 years ago, in 2006, gender identity or expression was added as the 18th protected trait in the Human Rights Act. Since that time, OHR has issued regulations and built campaigns to raise awareness around this newly added protection. The regulations specifically addressed restroom access, reasonable accommodations, name usage, and more. In addition to reproductive health rights, the rationale utilized in Dobbs signals that our rights pertaining to gender identity or expression, marriage, procreation, contraception, and familial and sexual relations are under threat. The Sanctuary Act addresses these risks directly by explicitly establishing that the district government will not participate in any investigation or proceeding seeking to punish an individual for seeking or obtaining contraception, aiding and abetting in the use of contraception, using contraception or providing contraception to another, engaging in sexual conduct made lawful in the district, maintaining relationships lawful in the district, cohabitation consistent with these choices, and providing, consenting to, or receiving or facilitating gender affirming care. And if a person or entity faces a judgment based on the exercise of these rights, the victim may pursue in the district a legal action against the party bringing such claim. The executive firmly supports these measures to uphold our DC values and stands ready to assist the council as necessary. So in sum, the passage of the two bills discussed today will make clear that in the District of Columbia, choices related to procreation, sexual relations, and gender identity or expression belong to individuals, not to the government. Thank you, Chairperson White and members of the committee for the opportunity to discuss these crucial pieces of legislation today, and I'm available for any questions you may have.
Thank you very much, Director. Let me see if Councilmember Henderson has questions. She may have...
I don't have any questions. I think Councilmember Nadeau and I kind of switched off here, so I'm gonna let her take it on.
All right, thank you very much, Councilmember Nadeau.
Thank you so much, Director. Thank you for your testimony. It was my intent in introducing this legislation to ensure that people harmed by the district's cooperation with a covered investigation can sue the district government. And that's why I put this in the Human Rights Act. Placing this in the Human Rights Act, though, also hypothetically gives people the ability to pursue administrative remedies through OHR. But it seems like OHR wouldn't be the go-to legal experts on what constitutes compliance with an investigation, that this might be hard for them to administer. Is it the position of OHR that the committee should add language to the bill clarifying that it creates a private right of action against the district government, but not the administrative remedies traditionally afforded by the Human Rights Act?
I think that's right, Councilmember Nadeau. I think that would be helpful, and particularly as is indicated in the introduction of the legislation entitling that section private right of action.
Okay, great. Wanted to get that on the record, and that is all that I had for you. Thank you, Chairman.
Thank you very much, Councilmember Nadeau. Director, I don't read the current law to prohibit our government from penalizing actions that harm or end a pregnancy against the will of the pregnant person. Do you agree?
I think, as you've discussed throughout this hearing, Councilmember, that's probably something that you may want to address. And so our suggestion is that perhaps adding some language in 2-1401.06 along the lines of voluntary requests or requests for assistance, and also perhaps create language, exclusionary language saying that this section does not apply to forced or coerced abortions. And so I think that may be helpful, but our office is certainly ready to stand by and help think through those developments of the statutory language.
I appreciate it. Yeah, and there's some overlap between my questions for you and the questions I asked to the Office of the Attorney General. We have some things we will need to work in concert on. One of the other questions I did ask to OAG that I want to pose to you as well, it's an important policy question that we need to resolve, which is how do we ensure that only the best and safest abortion medications are getting distributed and keep bad actors from preying on people in the district?
Thank you, Chairperson, for that question. Again, I think we will certainly think more on this, but our recommendation at the moment is similar to what I said earlier. You could similarly add language following the provision in Section 106 where it says seeking, inducing, or attempting to induce the individual's own abortion where FDA approved medication is used. Something akin to that may be helpful.
Okay. And that clarifies some of my other questions. I think that apply. For instance, how we possibly define self-managed abortions. We may need to tie it to FDA approval. So this is something that we will work through, and I assume you all will be willing to work with us on these issues.
Absolutely.
You've suggested that the existing and proposed protections against government interference in abortion might be best enforced through civil actions and not through administrative complaints at the Office of Human Rights. Could you elaborate on why OHR is not a good fit for these cases?
Yeah, so I think similar to the response I provided to Councilmember Nadeau, I think that's correct, particularly since it appears from the intention of the currently introduced bill that it is a private right of action, so it might be best suited for civil action in terms of the clawback. In terms of the full faith and credit provision in, I believe, is it section, the new section 4, that would, with respect to interference and non-cooperation, that is something we probably want to think through, whether we want to have an administrative process as an alternative to the civil action. But certainly the private right of action piece seems appropriate, and it seems that is the council intention to keep it as private right of action. Therefore, a civil action would be the most appropriate. But I will say that when we are considering making amendments to this language, that we want to think about the impacts of the introduction and intention of protecting choices and discrimination based on right to choose. And so I want to make sure that we don't throw away the baby with the bathwater as we separate out the different processes to follow with respect to the different rights and provisions.
Do civil penalties come through OHR in other contexts?
Do civil penalties come through? Do you mean, do we have authority to assess civil penalties? Is that what you mean?
Yes.
Absolutely.
That's okay. And so I guess help me understand why these civil penalties wouldn't be best coming through OHR.
No, I think that's why we want to think through this carefully about the pieces that we want to separate out. So in terms of the private right of action, it seems that one, we don't have statutory structure to assess damages related to the current provisions in 106 and the amendments following 106 in the proposed bills today. But we want to think through what the intention is. And certainly if the intention of the council is to keep it or consider keeping it in the administrative process, that we could think through that. But with respect to private right of action, you're going to have interstate disputes that may be better equipped for Article 3 courts versus OHR. Yeah. But with respect to the other provision regarding the non-cooperation of government participation in investigations and proceedings, that is something that we can think through whether or not it's appropriate for there to be an administrative alternative to the civil action. Okay. If that clarifies my.
Yeah, I'm clear now. I appreciate that. Okay. Is there anything else that you would like the committee to consider in connection with these measures?
The only other thing I would say, Chairperson, is that, as you know, with every piece of law that we get, and I think AG Racine touched on this, we want to think about promoting, educating the community, including the courts, about the newly minted laws. And so I think it would be helpful if we thought together about the types of outreach and education that we want to make to effectuate this very important pieces of legislation and ensure that there is obviously funding consistent with those intentions. So that's the only thing I would say, is to think through allocation of resources for education and outreach. And I will say that a few months ago, OHR did a training for the courts, and the judges were absolutely delighted, and it was particularly focused on gender identity or expression, and they were just happy to get our training. So I think they would welcome this as well. We certainly reach out to Office of the Attorney General to collaborate and work on that together.
Well, on education and outreach, do you have any thoughts on what kinds of resources that would require?
I think it would depend on how we finalize this legislation, Chairperson. And once we do that, we can have further engagement about what those outreach and education efforts might look like.
Okay. Those are all the questions I have. I want to thank you very much, Director, for your work on this, both prior to this hearing, but also going forward as we move this legislation along. Again, I want to thank my colleagues, council members Nadeau and Henderson, for their very thoughtful bills at a very important time. And I want to thank our public witnesses for their thoughts, experiences, and expertise. I also want to note that if there's anyone who wants to provide testimony on these bills, written testimony is welcome and encouraged and will be made part of the official record. So anyone interested can send testimony by email to the Committee on Government Operations and Facilities. You would send that to facilities@dccouncil.us, facilities@dccouncil.us. The record for this hearing will close at the close of business on Thursday, July 28th, 2022. So you will want to submit testimony prior to that. With that, the business before this committee is concluded, and the time is now 4:21 p.m. and this hearing is adjourned. Thanks, everybody.